Hi, chat. Well, we got some great, we got updates. They're not great. Actually, they're not good. They're bad. We'll put it like that. So, yes, this is the ongoing saga of the Young Thug trial and the recusal issue surrounding Judge Glanville. And with us again tonight is the esteemed Steve Gosney.
You got me hooked on this case a little bit, but yeah, this will be my last stream for quite a while, I think. I don't know. I've got tomorrow morning early. I'm leaving for Miami.
Okay.
So
if you guys,
thank you.
Oh yeah, let's start in the new adventure out there, which is going to be really cool, by the way.
Right.
So, congrats on that again, Steve.
Thank you.
So, if you guys aren't familiar with what we talked about before, Young Thug and the YSL group are on trial facing RICO charges. Basically, the prosecutors accusing the record label of acting like big street gang. In this trial, a gentleman named Lil Woody, who has the best Instagram ever, he's just out there hanging out, living his best life, was supposed to testify last week, and he refused. So he was held in jail over the weekend. Then on Monday, the 10th, the judge and the prosecution hung out with Lil Woody. And where's his? Yeah. With all his stacks, they hung out with him in chambers without notifying defense counsel and coerced testimony from him, and told him that he would no longer be held in contempt if he testified, and then he would get to go home. Well, shortly after that, Young Thug's attorney found out about the hearing and told the judge, hey, we heard about this. And the judge's first response was, tell me who told you or I'm going to hold you in contempt. Now, Brian Steele, who is the lead attorney for Young Thug and kind of like the leader of everything going on, refused to tell and was held in contempt, and is still held in contempt by Judge Glanville. That has been appealed up to the Georgia Supreme Court, and that's been put on pause. So the trial's still going. And this issue of the ex parte hearings, the witness tampering, and all the impropriety, Judge Glanville's refused to address it.
Now, I have a question about this. Because, and this relates to the ex parte discussion and all this. Okay, so this guy is a free man, a free citizen. This guy right here with the money.
Lil Woody, yes.
And they subpoena him for trial. He shows up. He claims the Fifth Amendment. The prosecutor allegedly immunizes him, although they can't immunize him for federal statement. He says, well, I'm still not going to testify. They hold him in contempt. He then says, okay, I'll testify, sure, but I'm going to lie my ass off, right?
And we covered that.
Now does it, okay, first of all, that's a Brady material. And second of all, doesn't that purge him of any contempt? Because he now is saying, I will testify. You may not like, I'm going to say whatever I want. But now the judge is intervening and saying, you must testify to a particular statement or a particular theme, or else I will retain you indefinitely. Now think about that. You're just an average citizen walking around and they say, okay, now you're in custody and you've got to testify the way we want you to, or you're in jail indefinitely. Isn't that what we're doing here?
Pretty much. And when he told the prosecutors, well, I'm just going to lie, that's fine, we won't prosecute you for lying.
By the way, I think those were all ones, and there was $100 bill on the top.
Yes, that's probably, you know what, though? That's still more $1 bills than I've got. That's a lot of $1 bills. That's the best gangster.
It's like a penny jar.
Yep. Now, what that caused an issue was he did come into court last week, and I covered this on my Thursday show, and he said, man, I'll tell you whatever you want me to say. I'll come and lie about everything. I'll lie about anybody. So he's already admitted to that. He did it on the stand, and it was very funny because he was in the middle of it and in the middle of court, and then he told everybody he was going to lie, and by golly, he started lying. So it was very good for him.
Yeah, well, now, but to purge himself, this is civil contempt. To purge himself, he needs to agree to testify. And it's like, okay, well, so now I will testify. I'm just going to say what I feel is that now you're saying, okay, now we're interfering with the content of what he's going to say. And to me, that's outrageous because it's like, okay, how do you know that he's lying? First of all, can they actually prosecute him for perjury? Do they know? If he just makes it up, I mean, I'm just saying that the judge is weighing in on content, which is way out of line.
Yes.
Which, no, I mean, this judge is off the risk.
Yeah. Well, we talked about this last week, Steve. Yes, the way you safeguard against somebody lying on the stand is you make them proffer early.
Right.
You make them sit down and spill their guts, but they didn't do that here.
But if you don't do that, then you're kind of at the mercy of the witness.
Yeah.
To hold him indefinitely because he's not saying what you want him to say it's like communists. It's like communism.
It is.
I mean, that's like, okay, you have to sign this confession. Sign it. Well, just don't make things difficult for us. Just sign. Right? Yeah. I mean, it's right out of Kafka.
It is. And it's Trenton saying Woody / his real name is Kenneth Copeland is on federal probation. Okay, well, yeah, so they don't screw around. Yeah, I don't know if it helps them, but yeah, he's probably been told to not screw around. But I'm sure his federal PO doesn't like hearing how he acted lately. So in response to all of this, Brian Steele has not revealed who told him. Judge Glanville subpoenaed and basically show caused everyone who was in that ex parte meeting, the DAs, the defense attorney for Copeland, all the court staff, and anybody else in that courtroom. They have to show up and explain why they're not the one who did the leak.
Okay, question. What privilege or order was being violated for which a basis for which the show cause can be made? In order to do a show cause, there has to be an order, a rule, or some confidentiality. I don't see there's any confidentiality. There's no order in place. There's no basis for the judge to order anybody to do anything in this case.
Exactly. Well, and he sent that to everybody, including the attorney who was there for Lil Woody, Kayla Bumpus, and she actually responded. And she filed a motion to quash the show cause order.
Okay, let's see.
This is actually pretty good. It's very interesting because...
and this will have interlocutory effect because you're forcing somebody to do something without basis. I haven't seen this before.
Yeah. And she is and she's got to quash the show order cause and the motion to recuse the court. So she comes through and she filed this on the 14th. So the recitation of facts. On Friday, June 7th, the state immunized Kenneth Copeland and called him as a witness. Copeland refused to testify. At that point, he was jailed. On June 10th at 8:30, Copeland and his lawyer, attorney Kayla Bumpus, were escorted in the court's chambers and conducted an ex parte meeting regarding whether or not Copeland would testify. Those present for the substantive portion of the ex parte meeting were
this judge, is great. Okay.
Copeland, the attorney, the ADAs, Adrian Love, Simone Hilton, and we already covered it. These are two of Fannie's higher associates. These aren't just a couple of rum-dums straight out of law school. She's got her very important people on this. The court security staff and deputies, 2 investigators from the DA's office who are basically detectives who work for the prosecutor, and a court reporter.
Now, why not, if you were a trial attorney, why not just order the transcript from the court reporter directly?
They've already, we're going to cover that issue.
All right. Sorry. I'm jumping ahead. I'm just thinking creatively.
No. Just we actually have the clips of that happening.
Okay.
And if we run out of time, I'll let you see them real quick before we go. In chambers, the court asked Copeland whether he was prepared to testify. Copeland announced he was planning to invoke his Fifth Amendment privilege. A conversation occurred among the parties regarding his understanding of immunity, how Copeland thought he may testify if he didn't invoke the Fifth, and certain facts of the case. Copeland learned he could be held indefinitely by the court if he refused to testify, which at some point the Court of Appeals is going to get involved in saying, no, let him go. You can't literally be held indefinitely. But there's years and years of this trial. There's still multiple people in the group have not been tried yet.
This is called a loophole. And this is like, people are always talking about defendants getting off on a loophole. Here's an example of a prosecutorial judicial loophole by which they're using as a threat against a witness.
Yes. So Copeland decided he would testify. He added his testimony would be a lie. The meeting ended and the parties went to the courtroom.
I love how she's laying out the content of the meeting in her motions. Like,
Yes.
F you, judge. I'm going to say what happened.
Oh, yeah. It's
Yeah.
great. So she says the ex parte was not placed under seal.
Okay.
There was no
No
protective
order. Right.
and that directed disclosure of the communications were prohibited.
Right. Right.
No attorney-client privilege ever existed, and that's
Exactly.
correct because multiple people were in the courtroom.
Right.
So it's not under seal, there's no protective order, and there's no privilege.
All right.
Those are the three ways things stay quiet.
Right.
And then the court never stated, ruled, or inferred that the meeting was meant to be confidential.
Right on. Great.
Which the only way it could ever order that is by doing these things up here.
And I've never heard of the court. Let me read those again. You would have to protective order.
Protective order.
No attorney-client privilege.
Not under seal or attorney-client or any sort of privilege.
Right.
And there is no privilege speaking to the court like that.
No.
Now, there's times where the court may do things in
No,
camera,
in fact,
but
as we talked,
gets to know.
As the defense said, there is mandatory Brady disclosure here.
Yes. What did he say in there?
He said, I'm going to lie on the stand. That is something the defense needs to know immediately.
Yes. And he is not, and the state we're getting to the point where the defense is about to cross-examine him. So
right. They need to have that they need to know that while he's being questioned, because if you don't know that and he's being questioned, you aren't aware, you aren't listening for that.
You don't know where he's lying if you don't know that he's
just so people know, Brady is a federal court case that requires the prosecutor to immediately turn over that type of impeachment information as soon as assuming that that this thing is right, that this ex parte, which it's not, as soon as they walk, the judge and the prosecutor should have told the defense this is what happened.
Yeah, they should have walked in and told them, and that didn't happen. They were going to lie by omission.
Right.
Further content of the meeting was not secret or protected in any way privileged. And she said if there was any privilege, such as attorney-client or work product, the privilege would be destroyed with all of the parties present, particularly the court reporter, and that's correct. And work product is something that if you generate it, so for example, if Steve's a prosecutor and I have notes, Steve doesn't get those. That's work product. It's something I created.
Right.
If the court reporters put it on the record, that's meant for everybody to know.
Right.
And that's a good point that she and her attorneys put down. It's unclear why any person present would have understood the content of the meeting could not be shared with the attorneys of record, who are also fellow officers of the court.
Right.
And that's just, I like that. Like these guys are good guys. They should be allowed in. We should be telling them. Later that same day, defense counsel Brian Steele addressed his court to make a record of his due process concerns regarding the meeting. Hold on, Steve.
Yeah, this is great. This is what I've been looking for. This is like red meat. This is I love this motion. I want to see who drafted it.
Okay, later that same day, Brian Steele addressed the court to make a record of the due process concerns regarding the ex parte meeting. The content of said meeting would not be non-confidential, but we give it to the defense under Giglio v. United States and Brady. And guys, we talked about this last week. There's Brady, there's Giglio, there's Bagley, there's Kyle's. There's a couple of different cases where they talk about this, that you have to provide this stuff. This is exculpatory material, and
Brady is something that's so obvious and so, and it's much abused by prosecutors. Giglio is a rarer thing. What Giglio is when you have potentially exculpatory information. No, I'm sorry. Giglio is when you knowingly put on false testimony, which is what this prosecutor was just about to do. The guy says, I'll lie my rear end off. She puts him on the stand, swears him under oath, and she asks him to lie. That is a Giglio violation. Here we have a judge participating in a Giglio violation, which I have never seen. And I asked Andrea Burkhardt on a Twitter chat, and she's never seen. I don't know anybody who has ever seen a judge participating in a Giglio violation.
Well, it's weird because with the Giglio issues.
I always call it Giglio, but I don't know.
Giglio. Yeah. Well, that's the way my professor called it, was Giglio. But he was kind of like a dorky guy from the Midwest, so I'm assuming he's, it's like, we're gonna have quesadillas. Yes, and Giglio concerns whether or not, if there's also been promises. They promised, we will not prosecute you if you go in there and testify. He's like, I'm gonna lie. We're not gonna prosecute you if you lie. And they, that's a big deal. That's a very big deal. They promised not to prosecute him.
And we need to, the defense needs to know that before
Yes.
the questioning.
Yes. During Attorney Steele's attempt to put his due process concerns on the record, this court began to focus on the identity of the source who leaked the meeting to the defense counsel. The court ordered Steele to provide the names of the person who divulged the existence of the ex parte meeting. Steele refused, like a homie. A brief hearing followed, and what appeared to be a classic civil contempt action. The attorney could purge himself if he provided the information, became criminal contempt. The court found Steele in criminal contempt and then sentenced him to the maximum time allowed, which was 20 days to serve in the jail. Now, it was over the course of 10 weekends. And I'm surprised it's 20 days. Here it's 30 they could do. Steele's on an appeal bond, and his proceeding was stayed by the Georgia Supreme Court. So like I said, guys, nothing's going to happen to the attorney anytime soon. And by anytime soon, I mean never. He's never going to go to jail. On June 11th, this court entered a show cause directing all individuals who were present and all representatives that were in attendance to show cause why one or more of them should not be held in contempt for disclosing the information from the ex parte conversation to defense counsel. No names were included in the order other than Copeland and attorney Bumpus. Now, the argument is, and here the court seeks to hold the contempt the person who leaked the ex parte meeting. Thus, the contempt will be about who informed defense counsel, whether to find that person guilty of criminal contempt, and if contempt is found, the appropriate punishment. The procedures that a trial court must follow to hold a person in contempt depend on whether the acts were committed in court, which I would argue we have an issue here because it's, hold on. Oh, what happened? Oh, yes. Sorry. 2.0 is like, hey, did you see this? She's like, oh, I guess you're already working on it. So, sorry, where was I? I'm so sorry, guys. Where was I here? The procedure the trial must follow to hold a person. There is direct contempt or out of court contempt is an indirect contempt. So there's already differences, guys. There's criminal contempt, civil contempt, and then it becomes an issue of, was it in court or was it out of court? Now, this is interesting. This is interesting stuff they get into here. An alleged contumacious act may only... Is that the right way to say that?
I don't know. What is that word? That's a word I am not familiar with.
I've seen it before, but I've never had to use it myself.
Let's look it up because I'm sure we're not the only fools here who...
Contumacious. Stubbornly or willfully disobedient to authority.
Okay.
Yes. So, well, hold on here. Contumacious. Okay, Google told me the right way.
Katie, bad girl.
Oh, did she? I don't want to know what they just said.
So just let it slide.
Okay. So yes, this alleged act. Oh, what'd you just send me, Steve? Oh, Baptiste. Yes, that's what the court starts hammering on. But
yeah.
So the alleged disobedient act may only be said to have occurred in the presence of a court, warranting summary contempt proceedings that the act was committed in open court. On the other hand, where the contumacious act are committed outside the court's presence, the considerations justifying expedited procedures do not pertain. If it's not in front of the judge and it doesn't happen in court, there's no immediacy. Like, he can get to it later.
Right. And let's set back up for a second, because what direct criminal intent is for an outrageous defendant who is cursing and throwing things or acting up and shouting and acting like that, and disrupting the flow of the court, not objecting and being a lawyer and standing at the podium and representing your client. That is not what it is. Like, you're holding up the process by your objections. That's what judges want it to be, maybe.
Yeah.
But that's not what it is.
No, yeah, it's not what you want it to be. It's the stuff you're not supposed to do. But this is not one of those times. Where is? Hold on here. What did this person just send me?
Funny story. I remember we had I had a like if Katie was in the courtroom and the judge and she starts using that word, right? The judge could say that again, and I'm going to hold you in contempt because you're just everybody's laughing in the whole courtroom, and we're trying to. And then she leans into the microphone and says it again, right? Boom! I'm going to send you to jail for 5 days. Go back. Well, we usually what a good judge might say. I'm going to send you to jail for 1 day. So come, y'all see you tomorrow at my next court date. Now, and then we'll see how, and you'll see how you clean up your mouth and come back. That it's a tool for the judge to control the courtroom. That's
and like you said, Steve, you've been threatened with contempt before. A lot of attorneys have been threatened with contempt before.
Well,
rightly or wrongly,
by one judge only on the nasty 4-day trial I had. But other than that, I've never even been remotely close to contempt. Although I feel it, I don't do it.
And due process requires that a person who's tried for indirect criminal contempt is entitled to more normal adversary procedures. And that's true because direct contempt, criminal contempt, it's happening right then and there. Everybody saw it. It's generally very clear. The court can say, what do you have to say for yourself? And then the court will think about it. And the court will say, cool, we'll see you tomorrow. Like you said. Now, if it's indirect contempt, you have, the court can't just make decisions on like, oh, I heard you did something. It has to be proven. It's not like it happened in front of the judge. They have the right to be advised of the charges, have a reasonable opportunity to respond, and be permitted the assistance of counsel and the right to call witnesses. And I have seen attorneys where the judge says, I'm going to hold you contempt. And the attorney's first thing is, Your Honor, I'd like time to have counsel. Because if you're being held in contempt, it's a serious matter. Now, this is the interesting part here. The disclosing information from the conversation to members of defense counsel occurred not in open court or in chambers, which you have to, if you're doing stuff that's like being in court. And even worse, you're in the judge's office, but that's like the courtroom at times, depending on what you're doing. But at a time and location that defense counsel were notified of the ex parte meeting, which I think it's really interesting. Like, how exactly do you know? Now, I understand Brian Steele has said, well, I didn't get it in this situation or that situation. But it's very interesting the way she's wording this. Like, I know where it did or didn't happen. Then she says direct contempt involves contemptuous conduct in the presence of the court, which generally results in immediate punishment. Here, the need for punishment is clearly not immediate, as the show cause order is being set for 2 weeks out. And that's a good point. It's not immediate. 2 weeks from now, the court's saying, well, we'll get to it. And then there's civil and criminal contempt, and those are further divided. Civil contempt's a punishment intended to coerce somebody to comply. Like you said, do what I say and we will purge it. Criminal contempt imposes unconditional punishment for prior contempt to preserve the court's authority. Like you said, if you come into court and start dropping F-bombs, and to punish disobedience of its orders. For example, somebody who just starts violating court orders willy-nilly in front of the judge in court, you're going to get held in criminal contempt. Now, the contempt alleged is disclosing information from the ex parte conversation to defense counsel could only be criminal contempt. Nothing can be done to purge or undo that alleged contemptuous act, and any punishment would amount to criminal contempt.
Whoever drafted this is a very good attorney.
Yes, it's very
logical and builds itself and very thoughtful. I love this lawyer, whoever it is. I'm looking at skeet sheet to the end.
I almost want to say it like we almost don't need to. The way I've been reading this, I'm like anybody could read this and figure it out. But that's how you know it's very well written. If anybody can figure out what's going on, that's how you know it's good stuff.
Right.
Now, I'm not saying guys ignore us. No. Stay here. We hold the keys, chat. We are the wizards who can decipher this. Now, no contemptuous conduct occurred. So neither is nor was anything preventing the disclosure of this meeting to defense counsel.
Right. That's it. That's the point.
Yes. disclosure did not violate a court order. There's no
Right.
standing order
Right.
in place that bars or limits counsel for any witness from communicating with defense counsel for the defendants about the meeting and its contents.
Right.
And here's the thing: they point out that even if a protective order were in place that with a sworn key witness from notifying counsel, such an order would deprive defendants of their due process rights. You know, ex parte communications are presumed to have been in error. And then they talk about the Uniform Superior Court rules, and they say that ex parte meetings should be avoided at all costs.
Yeah, I mean, it's obvious.
And-
every attorney that has encountered this is in shock by what this judge did.
Yeah.
And you know, because even people like, I think his who's the fellow who practices in front of this judge?
He a long time. It's been a couple of years, but J-Rock said, yeah, the attorneys down there think this trial broke his brain.
Yeah,
Like he's completely lost his mind.
He has. I don't know what's up.
Yeah.
What would it count? I don't know. I'm baffled, really.
Oh yeah, this is very much like the judge. I talked about this in the Richard Allen case, the case in Indiana. When he gives his answers, it's going to be the dumbest answers in the world, because eventually he's going to have to explain it himself, and it's not going to go well.
I don't know. Let's finish this because I have a couple of thoughts.
Yes. And then they talk about the Georgia Code of Judicial Conduct. You know, they recite that again, the stuff we talked about. And this is interesting because to the extent the show cause order may be subject to a general demurrer. Now, a demurrer is something you can still do in Georgia. I don't know. You can't do those in Florida, can you? A demurrer?
It's a common law pleading.
Yes. It's a very old school pleading.
It's old school. It's old school language. Usually you don't use that word anymore. Yes. It's just called a different thing and it's more clear.
Yes. Yeah, we in like Ohio, our criminal rules and like all demurrers are abolished. So like if you came in and started talking about a demurrer, they're gonna laugh at you. But in Georgia, you have to use these words. Like I said, guys, every state is different. And remember, Georgia's one of the 13 colonies, so they hold on to those traditional Old English traditions. You know, they do everything a little differently there. And this is what a demurrer is at this point. Assuming is true the allegation of disclosing information from the ex parte conversation to members of the defense counsel, contemptuous conduct is not alleged.
Yeah, and let's stop for a second because this is an important concept, and I really like the idea of a demurrer in a criminal case.
Yes.
You can do this in a civil context. It's called a summary judgment motion.
Yes, this is, and if you guys have heard of this before, this is a 12B6 motion. Sure, let's pretend for the sake of argument it's true. I haven't done anything wrong, and now, this is just
the only thing. Actually, there is a similar. It's actually one of my favorite motions in Florida, and it's called a C4 motion, and that is a sworn motion to dismiss, alleging if all the facts as contained, if the most favorable to the state are true, it still does not result in a crime, and therefore it's dismissed. So that is, but it's sort of, that's what a general demurrer. It should be a lot more common because there's got to be other vehicles aside from trial that we defense attorneys have to prevent the state from going forward. And this is another tool. And it's a tool that would, yes, everything you're saying is true, but that's not criminal, which is what demurrer is doing. And I would like to see more of that in Florida, but we push everything to trial in Florida, sadly.
So, yeah, guys, and I know that's a simplification of, but really, this is basically, yes, they failed to state a claim upon which relief can be granted. And the relief the judge wants is contempt. This isn't an illegal action. I didn't break the rules, so I can't be in trouble. Now, contempt may be found only where the attorney knows or reasonably should be aware in view of all circumstances, especially the heat of controversy, that he is exceeding the outermost limits of his proper role in hindering rather than facilitating the search for truth.
Where's that from? That's a quote from something.
That is a quote out of looks like Henry Jefferson.
Yeah, so that's a Georgia Supreme Court case from 2008.
Yes. Disclosure of the meeting did not exceed the limits of anyone's proper role. If anything, Disclosure facilitated the search for truth.
I love
I
it.
love how they're talking about, but look, Judge, it actually did. They're like, whoever did this, I'm not saying who, but Judge, whoever did it did the right thing, which I'm thinking it's the person that's the subject of this motion is the one who did it. A judge may reasonably expect his clerks and other judges to keep what happens in chambers professionally private. However, they are under no legal authority to do so, and that's correct. But if you're a clerk and you start talking about your judge's business, you're not going to be a clerk very long. And
Although,
no judge is going to want you.
Although deputies are amazing what deputies will tell you.
Yes, they will. The court deputies, everybody forgets about them, but they see everything
and they listen, and they're invented. They listen, and I love bailiffs. If you get, they can give you good insights into a lot of stuff.
Oh yeah.
Yeah.
And that's the thing, guys. The jail staff and the court staff, they're hanging around, and the deputies are always just there, but they never talk.
And so they get forgotten about. Like I said, I'm 90% sure it's the defense attorney, but it might be one of those deputies or one of those court staff,
Yeah. Yep. It's really just going to be interesting. The expectation of privacy does not extend to third parties not part of the court staff. And yes, especially if you're in the middle of a case, you can't expect the opposing counsels, the prosecution and the defense, to keep what you talked about private if it's the matter of trial. Holding an ex parte meeting in chambers does not impose a duty of secrecy. And that's true as well. Just because you're in the judge's chambers does not mean it's secret. There have been multiple times where, like if there's an issue during jury selection, there are some judges I know, everybody gets hauled into chambers because you can't get rid of 50 people and clear out the courtroom. You take the 5 people, the defense attorney, the defendant, the prosecutor, and the court reporter, or the bailiff, and you guys all go in and talk.
Yeah, and this is the thing. Everything doesn't happen with with a bench, and so sometimes you'll have little hearings, and there's no jury, there's nothing, and it's just the attorneys, and you'll sit back in the judge's office around a table, and that's court.
Mm-hmm.
Yeah, people don't see that side of it, but a lot of stuff is done that way. But it has to be. Other parties have to be present.
Mm-hmm.
You can't talk without. It's just so fundamental. It's hard to even repeat yourself.
Yeah. Informing counsel for the defense of the existence and content of this chambers meeting did not violate any rule of law, trial order, or standing order, and is not a basis for contempt. The show cause should be quashed.
Right.
And once again, this is that standard saying the judge failed to state a claim of relief. He fails to state a claim upon which he's entitled to impose contempt.
Right.
So think about it, guys, just like a summary judgment motion. This court must transfer the contempt matter to another judge under procedures, or alternatively recuse itself, pursuant to Rule 2.11. So the judge may not preside over this contempt proceeding because the court does not satisfy the following criteria. In indirect contempt actions, the trial judge who's presiding over the trial during which the alleged contumacious conduct occurred may preside over the contempt hearing if, and this is if, the contumacious conduct was not directed toward the judge and the judge did not react to the contumacious conduct in such a way as to become involved in the controversy. Well, he's made it all about him in the meantime, so yeah, that's a very good point. And once again, it's from the Georgia Supreme Court. That's a bit of an issue now. I think the judge has made it about him.
Well, yeah, okay. I got thoughts on that, but I want to say.
No, you can go for it. What are you thinking?
Well, the thing that I really keeps coming up that I've been thinking about since our last stream, and I've been thinking about this case, and I've been kind of seeing snippets of it. Mm-hmm. Okay, if you are an attorney and you are stealing money out of your trust account, the Florida bar will do an emergency suspension of you because you're an imminent danger to your clients. Mm-hmm. I think the Georgia bar needs to suspend this judge immediately because he is an imminent danger to everybody in his courtroom. It's an emergency situation. It's an emergency abuse of power. And I think it's required in this case. I mean, it's a little unprecedented, but so what this judge is doing is quite unprecedented. And I think it would not behoove the Georgia Supreme Court or the whoever, if they have an integrated bar, or the bar to the bar to suspend his license immediately.
Oh, I agree.
Yeah. And then he could not be a judge. He could not continue to preside because he would not be a licensed lawyer at the time. He would be an emergency suspension with a hearing at a later date. And that's what needs to be done with this judge. I think that's one remedy. There's others, but that's the one I was thinking of.
Oh, I agree.
Because if the courts, the appellate courts and the Supreme Court don't act, the bar itself should act. Because this is a danger not only to every lawyer, every client, everybody in that courtroom. It's also a danger to the criminal justice system itself.
Well, he's already caused untold damage to the criminal justice system.
Oh, yeah. I mean, those young thugs over there, it's like, see, the game's all rigged. We were right. You just empowered the thugs, young thug.
Well, here's the thing, Steve. I mean, they don't have, like, this has not been a very impressive case against these guys. Like, I'm not sure that, like, who knows what they actually did or didn't do on top of that. That's the bigger issue. These guys have been sitting in jail, and, you know, even if we recuse, it's like these guys might have to sit in jail for another trial to get going. And how is that fair to them? If they're innocent, they've been sitting in jail for 4 years because some judge fucked around and didn't want to be an adult.
We're so in la la land that the case has been completely taken over by side issues. This is very bad prosecution, and it's unethical. Yeah, I would say criminal, tyrannical judging.
Oh, I think so too. And JL saying, when will this show cause hearing take place? It's set for the 25th. Now, I'm sure the judge is going to deny this motion.
And when he does, it will be an immediate appeal to the Georgia Supreme Court, and they will suspend it. I think by adding the recusal, they might just kick him off the case based on all of these motions that you're seeing now. To me, are looking for interlocutory appellate relief.
Well, he's denying all of that, but yes, you could file them. You can always file motions, guys. You can always file an appeal. It's always, is it a final appealable order? All of these are final appealable orders when he denies them. It's just whether or not he's going to agree to pause the trial while you seek that. That's a separate matter. These courts will hear him anyway. And yes, I think this is all still tactically being done as a part of a larger group of things as well.
Yeah, here, this is good. The sacrosanct nature.
Okay.
That's a good paragraph.
Okay.
And hit the thumbs up, by the way, if you haven't already.
Yes. Hold on 1 second real quick. I just need
And I think your super chats are piling up too.
Yeah, they are piling up, Steve, but I know your time is precious, so I don't want to.
That's okay. I'm having fun. I'm all energized.
Steve, give me 1 second. I need to address this real quick, guys. Give me one. I apologize.
I'll read the next paragraph. So here, the alleged contemptuous conduct was, as expressed by the court, directed at least in part towards the court personally and the sacrosanct nature of its chambers. That was a judge used that word. My chambers are sacrosanct. The court became involved in the controversy both by holding the ex parte meeting in the first place and by way of the fact that this court is a witness to the potentially disputed fact of whether there was any kind of order to not disclose the meeting to counsel for the defense. Okay. The Georgia Code of Judicial Conduct Court, I think that's a mistake. The Georgia Code of Judicial Conduct, I think it should just it should be dictates recusal because the court's impartiality might be reasonably questioned.
Yes. All right.
Okay. I'm down there to the first sentence of the second paragraph.
So when considering the issue of recusal, both the OGA, and that's a state code, and Canon 3 of the Code of Conduct should be applied. And this is where we talked about this before. Judges shall disqualify themselves in any proceedings which their impartiality might reasonably be questioned, or in which the judge has a personal bias or prejudice, and I think we've established that by now, concerning a party or a party's lawyer. And the way he went after Brian Steele and the way they've been going, and the way he threatened the other attorney last week, where he said, you need to mind yourself.
Yeah, and it's this case,
Mhm.
the judge at this point, I'm expecting him to deny everything, no matter what the law
Oh, yeah.
says. And the reason you watch The Sopranos, and
Yes.
there was a scene, and there was this doctor who the guy had cancer. I think it was Johnny Sack had cancer, and
Yeah.
this guy who was the orderly in the prison has like committed a murder, and
Yeah,
he's
he's a
like, "Oh
doctor,
no,
yes.
you remember I'm a doctor," and he's like giving
Yeah.
him other advice. You remember when he comes in, he's like, "Well, what's your story, doc?" And he says, "Well, he's like, well, I killed my wife or whatever it was, and then
Mhm.
the postman showed up, and I
Mhm.
killed him too." He's like, because at that point I was committed. You
Yeah.
know, that's what's going on here. It's like he's already killed the first person,
Yeah.
right? You might as well kill the
Well,
witnesses too. You're
that's
committed,
well, Steve, you've heard that saying, the first murder cost you, the rest are free.
right?
And
Right.
that's the thing here. This judge, if he had stopped right then and there at the ex parte thing, he might not have lost his bench. He's still going to get heavily disciplined for that because that is unforgivable, what he did. But
Yes.
I guess the judge is kind of like I said, it's like that book I read. Oops, we accidentally fired a missile. I guess we better fire them all. And he's just going to keep going until somebody stops him.
See, I don't know what the Georgia Supreme Court or
Mhm.
bar looks like, because if your bar and court are corrupt also,
Yes.
then this is what justice looks like in Georgia.
Well, I don't know. I kind of get the feeling even if they're corrupt, there's too much heat. They're going to have to act.
And to have to do nothing. I don't.
Well,
I'll believe it when I see it. I'm just making the point that you
yes.
put corruption bleeds its way right onto the top. These people take power.
Yes, it does. Yes. Here the court's impartiality might be questioned for 5 reasons.
5 reasons. Okay, let's
Yes,
see
quite
it.
reasonably. First,
Count those reasons,
the
baby.
court stated, yes, this is so sacrosanct to have a conversation in my chambers. Parroted to you and others, it is that serious. Revealing the court reveals the harm to be at least in part a direct harm to this court personally and or the sanctity of his own chambers, which that's not how this works. Second, as described in the show cause order, some of the other participants in the hearing were the court's own security personnel. This gives rise to 2 issues. A potential witness they may have to testify at the hearing, at which time the judge will have to assess the credibility of their testimony. It might reasonably be questioned that this court would give more credibility to the court's own personal security personnel than it would to other witnesses such as Attorney Bumpus, which I think is fair. Who are you going to believe? Your court staff that you've had with you for 25 years or this attorney? And that's not fair to your court staff who are probably just regular government and regular civil servants. Your court staff, your clerks, those people have, for the judge to pit them in this situation, that really is a dirtbag move. Further, the court's own security personnel and the reporter, like Attorney Bumpus, are subject to being held in contempt. This court's impartiality might be questionably reasoned if it were to sit as both prosecutor and fact finder, deciding if it was the court's own personnel, reporter, or someone else who disclosed the meeting. I mean, and guys, this is the thing. This case is like issue upon issue, and each layer of this onion is so intellectually challenging because how do you do that? Third, this court has personal knowledge of a disputed evidentiary fact of whether there was an order of any kind barring disclosure. Well, the court claims that it wasn't allowed, but there's no proof of it. But the court claims that, so that's an evidentiary issue. Fourth, this court appears to already have decided prior to any hearing that it was Attorney Bumpus who made the disclosure. He said, while holding Brian Steele in contempt, he said, well, then other than if you were sitting here, unless you were sitting in there with the recorder or Miss Love or Miss Hilton, or one of the deputies gave you that information, or Miss Weaver shot you a rough copy of the transcript. Now, Weaver is the court reporter, guys. There's only one person that's left. And if that person gave you that information or shared it with you, she probably violated privilege.
What privilege?
Yeah, well, that's a very important thing. There is no talking to the judge privilege.
And the thing is that also it's not the judge's position to enforce an attorney violent privilege. What if her client says,
what if Copeland waived?
Yeah, waive. You go share it to them with my buddies.
Yes.
That's
Yeah,
possible.
guys, you're
Yeah,
telling me to check Discord chat here. Hold on. What's going on?
Yeah, so violating this is so, I have a saying,
Okay.
when I used to do appeals, and you run in an appeal and there's a problem in the courtroom, there's a good appellate issue. Usually there was 3 or 4 or 5 good appellate issues, because it's like when it rains, it pours. Once you start going down this path, and then it becomes a tangled mess, and you have to squeeze it out and figure out which one is the most successful. So what they're doing here, this attorney, whoever is doing this, or team of attorneys, is very good at issue spotting, and they are putting it together. They're laying out all these issues. It was probably a brainstorming of a couple group of lawyers, and
I'm
then
sure
a great writer here put it together.
I'm sure the entire Georgia criminal defense strike team, they've had everybody jumping in. Well, they call that here in Ohio. It's called the strike force, and they'll show up at the drop of a hat. Because they have people over the state. Guys, and real quick, yes, I got the DM. I will not air that document. Number one, I don't know if it's true. Number two, that document is from a confidential setting. Okay, that comes from juvenile court. Somebody fucked up that we have access to that. Really bad. And I'm not playing a game with some confidential documents.
Or juvenile courts.
Yeah, I'm not playing that game. Yeah, it's not good. It doesn't look good. I'm going to leave it at that. But I am not, I've looked at it. I just saw what it was. I am not fucking touching that. That is hotter than Chernobyl graphite for somebody like me. Because even though I'm not in Minnesota, I'm sure the Supreme Court of Ohio would say, "Why are you fucking around with shit like that?"
And
I will not.
And
touch
children are in a different league than public figures. So lay off people's kids.
Yeah. Well, and also, just like I said, guys, it can get read, whatever. I can't touch it.
Good, and nor will I.
There's a lot of things I'll touch, and I can get things leaked to me that I could probably get away with doing. That's not one I want to find out that I'm on the wrong side of the fence on. So, Luke says, I'm in New Zealand. Yeah, well, I'm not worried about you. I'm worried about number one. There's only one person I'm worried about here. And also, I wouldn't show this with Steve up here. Even if I was willing to take the chance, Steve doesn't need that on him. I wouldn't show that to anybody who doesn't want to be on with it. I just bring this up because when I was in law school, Snowden fled to Russia, and all the stuff got leaked. And my professor, we were doing international law. He's like, "Well, let's talk about it." And he said, anybody in this room, he said, for the next, we had a Tuesday, Thursday class. He said, for this week, if you are either in the military, wanting to go in the military, or trying to work for the feds at any point in your career, I'm excusing you from these classes. They will not count against you. Because he was showing illegally declassified material, which if part of your polygraph is, have you ever been unauthorized access to classified material? Well, now you can answer no, and you're not lying. But that way he gave everybody a free pass to get out of it. I wasn't doing any of that, so we read through all the prison files and all the cables and everything. It was interesting. So, yeah. So, anyways, guys, we're gonna keep going here. This court's show cause order reinforces this predetermination, as the order reinforces no other person present at the meeting by name other than Bumpus or Copeland. Fifth and finally, the court was visibly impacted when it learned the attorney Steele had been informed of the meeting. Yeah, the judge was really mad. He was very mad.
I wonder about that. He was mad because he got discovered.
Yes.
And I think the anger came from he's got his rear end handed to him. And then I think all of this stuff is basically a distraction, trying to change the subject, because the subject is not who violated the sanctity of the thing. The subject is why that meeting occurred in the first place.
Yeah. No, and that's the thing. Who dare defy my authority? So I think there's a massive issue here. So the Georgia Supreme Court referenced an opinion echoing this case, noting that a recusal motion clearly has merit, But what if the motion to recuse has merit? What if the judge who announced an oral ruling or reasonably appears to be partial or prejudiced and therefore has no business continuing to preside over the case? What if, for example, a party defending himself at a contempt hearing turns around and accuses the judge of prejudice, and the judge defends himself, then orally holds the accusing party in contempt? Yes, and that's where we're at. It's interesting. I love how they underline it.
And Georgia's Supreme Court 2018. Yes. Sounds to me like they might have a lot of problems like this. I've never had to delve this deeply into contempt stuff. Thank God.
Yeah.
I'll tell you, the only real experience I have with the contempt is, first of all, being the subject of one in a very difficult trial. But the other, sometimes you'll get difficult defendants when they're being sentenced and they mouth off and stuff. And the judge will say, okay, I'm giving you 2 years in prison and I'm adding on 60 additional days at the end of the thing. Take him away, right? Because he's such a mouth. So you'll see that. I've seen that a couple times, but not anything like this. This is crazy. And I will say that the wielding, the power happy judge here who is throwing contempt around like it's salted nuts is to me, that is a weak judge who does not have control of his courtroom.
No, and that's the thing, guys. Yeah, Glanville is not powerful right now. He's a very, very weak man in a weak position.
But they say a weak man is also a dangerous man.
Yes, that's very true. A man who's on the run is very dangerous. But as Beanie Siegel says in 1-900 Hustler, the strong move quiet and the weak start riots. This court is, I keep saying that, but it's so true. It's so true. This court has ample time to transfer the case to a judge who is not involved. And that's true because the judge was a witness. And that's true. He was a witness. He was there for it. I know who was there. And I'd also argue he's in a position of bias because, as we stated, he's got to determine whether the court reporter is someone he probably works with all the time, knows on a first name basis. The judge, like his court staff, they can they come over to each other's houses. They know each other's families. Yeah, I wouldn't want to have to compete against Carol and, the judge's court administrator to determine whether or not me or her is telling the truth. How the hell am I going to win that argument when it comes down to that? I've seen attorneys in those situations where somebody in the court staff said X and the attorney says Y. And I'm like, God, I do never want to be in that position because if you win, those people fucking hate you. And if you lose, good Lord, you're a dead man. So it's not a good situation for anybody. And yes, there's an issue about notice and fairly and fully informing the accused. When the contempt proceeding is criminal, the full panoply. I know. God, I just messed that up. I'm catching myself.
It's okay. Everybody tells me I pronounced Giglio wrong, so what can I say?
Yes. Protections must be afforded to the accused, and that's true.
Now, let's talk about this.
Yes.
It says notice. This court must provide notice.
Notice, yes.
And it's very much, due process. When we talk about the concept of due process, right? That's what does that mean? Well, it's what process you are due, and it's a graduating thing depending on the severity of the crime. Mm-hmm. But also the essence of due process is notice and the right to be heard. Those two things. So you have to have notice. What am I here for? And I should be able to speak on it. That is an essential component of due process in many, 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 many cases. And so what they're saying is, I don't even know what you're bringing me in to talk about.
Yeah. And it's just like if you were hauled in you got charged with a crime and period. You get a notice and get a summons in the mail, show up to court. You've been accused of X. You have the right to be notified of the charges. You have the right to be notified who's accusing you. And then you have the right to defend yourself. So this includes a notice fairly and fully informing the accused of the specific acts of contempt. This requirement of reasonable notice in a case involving alleged indirect contempt contemplates and necessitates a written notice fairly and fully informing the accused of the specific acts of contempt with which she is charged, and so given as to afford a reasonable time to make her defense. It sounds just like any other criminal case, guys. All the things you have there. Anything short of that would make a hollow mockery of the fundamental and abiding truth that reasonable notice to one whose civil rights or liberty may be affected is a veritable cornerstone of our judicial system. It would constitute nothing more than an exquisite exercise in frustrating futility, sometimes misleading and always meaningless. It would nothing be but sounding brass and tinkling cymbal, a notice in form but not in substance.
These are judges that get flowery. Note this is the appellate court.
Yes, this is somebody who was on law review.
Yeah.
This is what appellate judges. Some appellate judges love this because you don't get to do this anywhere else. If you tried this at the like a trial court, what the judge goes, "Yeah, I read your brief and we're moving on." Like, yes,
you have to be able to quote this, block quote it, because if a lawyer, you can't put this in your motion. Although I've seen lawyers do it, but it's generally not persuasive. But when a court does it, you can cite it and say, "Oh, this is brilliant poetry."
Yes, but I'm just saying. If you did this at a trial court, a lot of times you're probably just going to get tossed. It's not like you could throw in, Keats or anybody else into some Byron into your motions and things, and the court's going to notice. But if you did it like as an appellate level, they might notice that and they would appreciate it. But a lot of times at the trial court level, it's all underappreciated.
Oh, this next paragraph is fascinating.
Yes.
Oh, this is interesting. Yes. I am learning more about criminal contempt and
especially
civil contempt.
Georgia contempt.
Yes. Well, hopefully it won't be in Georgia.
Like all crimes, contempt has an act requirement, the actus reus, which is the act itself, and a mental component, the mens rea.
Right.
In Reed Jefferson, okay. The notice alleges an actus reus, but fails to put on Attorney Bumpus on notice of the mens rea that how the disclosure would know such an act amounted to contempt. And that's where, once again, it gets to the issue of privilege. Was there an order? Was there anything protecting it? Notice the alleged facts the notice does not allege facts from which contemptuous mens rea could be inferred. And that's the thing. Without being told you can't do it, how do I know not doing it is illegal? So as set forth above, the act of disclosing the meaning to defense counsel cannot in itself amount to contempt. The disclosure would potentially amount to contempt if it violated a court order or some other legal duty to not disclose the ex parte meeting. The notice fails any such restriction. As such, the notice fails to fairly and fully inform the accused of the specific acts of contempt. So therefore, she moves this court to quash its order to show cause. Not going to happen. Judge Glanville is going to make her show up. Recuse itself from the proceeding. He's not going to quit. Or transfer this to another judge. Not going to happen. Whose impartiality can't be reasonably questioned. He's not going to do that. Provide an adequate notice that fully informs Attorney Bumpus of the alleged contempt. That's not going to happen either. And should all the relief be requested denied, Attorney Bumpus requests a certificate of immediate review. And that's the interlocutory appeal, guys. That's not going to happen either. So that was submitted by Julius B. Collins. Here's the neat part, though. He's the attorney. She's got these two attorneys in her corner. And here's the thing, guys. She's not being charged for this. I guarantee you these attorneys are helping her. The idea these attorneys would be charging her for this would be ridiculous. These are attorneys helping each other. Nicole Mormon, like all these attorneys. Look at this. Look at this. The attorneys for Kayla Bumpus.
Show me that again. That's amazing because we've got Banks. But look at this. See, I love it.
2, 3, 4, 5.
Is this the strike
6
team?
Attorneys. This is probably a strike, like the criminal defense bar. But I'm assuming there's other attorneys in the area who are like not necessarily on that or members of it, who are defense attorneys who are like, I want to help. I've got some knowledge I can help throw in the fight here. Let me help out.
I will tell you, this is
a community coming together.
This is an excellent, very well put together work.
This is family chat coming together.
This is excellent work. I commend this defense team, and I think and I hope that these
Yes.
people are looking ahead to the interlocutory appeal to get this judge off this case and stop this travesty before it goes any further.
So, yes, guys, people are still spamming with DMs in Discord. No, I'm not going to do it. I'm not going to air the documents, even if they're legit. Like I said, I got no amount of grifting is worth my ticket. No amount of grifting.
Because the thing is that juveniles are protected.
Yes.
And there's a different standard, and we are officers of courts, and we have duties to not disclose anything or even really, because children are not in the targeting firing line. So let's leave the kids out of it.
Well, that's not that's not even the issue. That's an issue, I understand, Steve, but it's the issue of, as an officer of the court, I'm now airing truly confidential documents that nobody should have.
But it's also a moral issue.
Well, there's a secondary moral issue. I agree, but I'm saying specifically, first and foremost, even if I didn't have a moral issue about it, ethically and professionally, I've got an issue, and that issue that takes care of it, because now we're going to have to consider the moral issue.
Right. Well, I put the moral issue ahead of the ethical issue, but I either one is determinative.
So certificate of service, guys. Yeah, certificate of service. Just saying we sent it to them. Now this is the order to show cause, and oh my god,
that's an attachment, right?
Yes. This is just boo.
We already read. We did that one last time.
We already did it. Yes.
Yeah.
So this is it. Now this is interesting here. This is the affidavit. Is this the one that
we read that one also? Yeah, that's the one.
Yeah.
That was...
Oh no, this is different people this time.
Okay, what is this? Who are they?
This is different. Julius Collins of Kiston Nove, and
thanks. Oh, this is attorneys. The whole. Okay, these are the attorneys.
All her attorneys. Yeah, let's see what this one says real quick.
So an affidavit is basically, this is actually evidence. I mean, this is sworn testimony that you are presenting, that you attach. It's not required. Some motions require it, some do not.
Yeah. Okay, wait, this is just them basically stating, I'm assuming, all the information they know about everything else so far. Because they talk about Steele throughout this. So,
but this gives courts, a lot of times they'll say, well, these are factual issues.
Yes.
So this, and I don't know the Georgia rules, but sometimes you have to put factual issues, and then the state has to traverse, and sometimes, and if they can't traverse, then it's deemed admitted.
Yes.
So you have to. That's fun writing. I love writing those things.
Yes. Because
you write every sentence that they cannot be traversed, because every sentence is absolutely factual. Those are my favorite motions to draft.
Yes. So this is Kayla Bumpus, and her attorneys showed up. She has a team of attorneys there helping her out. But the judge, after Brian Steele filed a motion to recuse.
You want to do the super chats first, because we're way behind on the super chats. You haven't done any of them.
Yeah, but I also know you said you didn't have a ton of time.
I know. I have to go to bed, but I can't go to bed now. You got me all energized.
It's too late, chat. Yes.
Because I got to get up very early, so go to roll ahead.
Yes. Super Wiener says Steve the Ginger.
You know what I'm going to listen to? I've got to listen to the new Ginger live album, live in Los Angeles. I haven't heard it yet. I came in and I put it on my thing. We're going to listen to it on the truck.
On the way down? Yeah.
On the way down to Miami tomorrow. So
perfect.
Ginger is like my favorite band right now.
Yeah, and by the way, guys, if you could show Steve or tell him congratulations in chat, I'm sure he would appreciate seeing that. Starting the new job. You're going to be the new kid. You're going to be the new kid. You're going to your wife's going to pack you lunch for the first day. You're going to be like, hi.
Well, actually, I'm going to be all alone down there for a little bit. The wife's got to deal with things up here for a while. It's a convoluted mess. But anyway.
Pike says legal content on a law channel. Seraphim says thanks. I'm not sure what for, but you're welcome. EDW Raptor says juggalo violations.
Juggalos. Whoop, whoop. The juggalos. Never got into the juggalos.
Whoop whoop. Family. That's their thing. Cat Not Williams gifted 5 memberships, and EDW Raptor gifted 10. Thank you guys both for your generosity and support, helping to genocide the gray name tags down there in chat. That's how we look at it.
Thank you, chat. Chat's being awful nice. They're listening to you. See, they listen. They respond.
Well, they're well-behaved chattel. Darcy said, long crime, not my favorite. They had an Ohio judge on to talk about this. I'm curious to know which judge it was, because I know a lot of judges.
Oh.
He was cautious. He kind of said, I wouldn't have an ex parte only in specific occasions, yet both sides would know about it prior. Well, here's the thing. He is a judge. If he comes out and says, oh my God, this guy's a bum, that's kind of rough on the judicial profession, even though it's a guy in another state. I kind of get the idea he's not going to come out and say stuff. He's far more restricted than what me or Steve could say.
Judges, and they have this brethren thing,
Yes.
like we brethren, but you made a good point. They're also more restricted.
They all hide.
I feel like I'm in the high chair and you're on the low chair.
Well, I actually, my monitor, the power supply for that, the AC adapter went down. So I had to go into 2.0's office and take her TV, and I'm using that as my monitor, and the camera is not set up right. So it's just clipped to the top of it for now. So I'm surprised nobody's brought it up. I'm back to the old days where I was like all the way down here at the bottom of the screen. But yes, Darcy, I'm curious to know which judge it was. But yes, they all hide under that big black robe. Night Goblin King Shig, it's been a member 3 months, says, vote Lil Woody for 2024. Huh? What you mean? I guess. What more? America could use that right now. And then, oh my gosh, you guys are just like a green wave here. EDW Raptor for 10 memberships. The Amateur Iconoclast for 5. Selena for 5. EDW Raptor for 5 more. Cat, not Cat Williams, 5 more. And Cave Johnson jumping into the fight with 5 memberships. Just making it rain out there, chat. Like, guys, thank you. Thank you so much for your support there. Thank you so much. And thank you for the generosity. And Nick Dev says, I thought lawyers had classical educations. I'm a half retarded monkey that wears pants, guys. I've never tried to act like I'm not. But you guys have heard me on here. I marble mouth my way through stuff all the time. Stabby says, 45 gifted memberships, chat, and I'll make more promises I can't keep. Oh, and then EDW Raptor for 10 more. Jeez, you guys. Cedar Rose gifted 1. Thank you, Cedar Rose. EDW gifted 10 more. Luke gifted 1. J-Rock comes off the top rope with 10 more. EDW Raptor back with 10 more. Darcy with 10. Melanie M. Melanie, thank you. Thank you so much for jumping in with 5 more. Thank you guys for your memberships. Holy cow. Holy cow, chat. Yeah, I mean, there's a lot of 736 people in here. Yeah, it's a lot of green to make. Oh God, I know I messed up the last time. You got to tell me how to pronounce this, but
Oregon.
No, no, his name. Yes, Oregon v. Kennedy territory and double jeopardy should attach. Yes, I agree it should attach. We are well past, but then again, I'm the type of person where it's like double jeopardy should be attached pretty much out of nowhere.
Yeah, I know. Well, that's the defense.
You're at a pre-trial, double jeopardy's attached.
Yeah, I know.
Over.
Well, I'll tell you, there is a very good argument for double jeopardy attaching to this abomination of a trial.
100%. Oh, I agree. As Farrell is saying, it's Fanny's court. Of course it's corrupt. Fulton County, guys, Fulton County is and here's the neat thing. Fulton County's had issues forever, so it's not like it's because it's Fanny. Some places it's like Chicago. When was Chicago not corrupt? I don't know. But
it's like, remember when the feds would come over and take over a county based on segregation time? That sounds to me like what needs to happen in Fulton County.
Well, for example, Youngstown, Ohio, I'm sure you've heard of it before, was a notorious hotbed of mafia action. And the feds had an organized crime task force. And then it became a public corruption issue. And there was this public corruption probe the feds were basically running nonstop. They were indicting people left and right and going, it's finally now died. But throughout the 90s and early 2000s, people were just, getting smoked left and right with it. Bad Weather Biker for $10 saying, for sticking to your ethics, here's a super chat, Sean. #respect. Well, thank you. I appreciate that. Graxis for $50.
Do you have any kind of like horn that you can blow or anything like that?
No, I'm just like, wow. Thank you. Thank you very much.
Graxis.
The funny thing is, when I tell people I'm in the, the Cleveland area in the eastern suburbs, not East Cleveland. If I was in East Cleveland, I could do like a celebratory gunshot out the window. Graxis said the other night, I said if I got gifted a membership, I donate $50. I don't remember you saying that, but if you did, thank you. That's integrity's about what you do when no one's looking. If
That's
nothing
right.
else, if not a man of my word, the RNG gods finally got me. Well, I'm glad that you were able to get greened, because I know some people, there's like one of our mods, Tilly, he can't get a membership for some reason because of the way his account something's happened to it where he can never get a green membership. Scorpion says, Steve, I didn't get the story. What's the new job?
Oh, well, I'm going to, tomorrow, well, as of next Wednesday, I will be in the Miami State Attorney's Office. And my job will be to train all the young prosecutors coming in. There's one guy that does there now. I'm going to be added to that stable. They hire 80 attorneys a year. And so you have 80 young minds that need training in ethics and I will not be doing death penalty cases. I told them I will not do death penalty based on my faith. And they were cool with that. And I also led with a lot of these ethical questions. And I met with the entire leadership team down there, and they were very much on board. I think from top down, they want to be highly ethical, and but it's such a big office. They have over 500 attorneys in that state attorney's office. So I will also be, in addition to that, assigned duties by Miss Rundle, who is the elected state attorney down there, and advising on Brady compliance, ethical compliance, prosecutorial accountability, anything, and really anything else as a legal advisor to the elected state attorney there, because they said they needed a defense perspective because everybody's thinking like a prosecutor, right? But a lot of the defense attorneys they had didn't understand the prosecutorial function, and there's a lot of reasons for it, and I did a whole stream on it, but the really, when I think about doing another 500 appeals and maybe get my name on a couple court orders for every couple times a year, what does that really make a difference in the world? Whereas training young lawyers to be highly ethical and excellent attorneys as they're coming up, boy, that you can make a big impact. And I'm very excited about that. And it's a new adventure in my life for my family. And I get to spend more time with my son, who's moving to Miami to go to college.
Yes. So yeah, Steve, like I said, we wish you nothing but the best on that. And yes, and that changing of ethics in people, those attorneys, the next 30 years, they're attorneys, and hopefully they push that on. So it's, like you said, the ripples will continue.
And the thing is that, what is it, Aristotle that said that you are what you habitually do. And a lot of lawyers lose their ethics in their first job because they have an unethical firm or boss or something, or they're taught to cheat. And then that sets the pace for their entire career and has ripple effects. So if we can really establish some good habits on young kids, kids fresh out of law school, right? Then maybe we can make an impact in this world. And so I'm really excited about the opportunity, and the leadership team down there was excellent. I got to say, 5 stars, and it's part of it. It feels like I'm going home. And so that's a long answer for it, but thank you, Scorpion, for the answer if anybody's asking.
Steve, I think it's a great answer. And you're right, though. We are what a lot of attorneys do lose it, but that also becomes an issue of when people hate attorneys, and attorneys have shit reputations. Well, attorneys have earned that reputation over the past 200 years. I mean, attorneys have earned that.
Look at these prosecutors in Atlanta. How much damage are they doing to the rule of law? When you swear to uphold the Constitution of the rule of law. What they are doing is extrajudicial. It's extra lawful. They are undermining the rule of law on the very job that is supposed to enforce it. It is the worst thing that can possibly do. So this is the kind of thing that, I'm speaking very loudly, and you know what a critic I am. I've also trained prosecutors when I was a prosecutor for 6 years. And I trained prosecutors to do that. And I'm really looking forward to going back and having that impact. And, we'll see how it goes, but that's the adventure the COD's called me to.
No, and the other thing here is it's, I've said this before on stream, like these two ADAs who are doing all this crap, they're a bigger threat to America and the Constitution than the idea of ISIS showing up.
Yeah,
Because unlike ISIS
right.
maybe showing up someday, these guys are here actively right now taking a jackhammer to foundations of things that we have and what little we have that's still stable and still has integrity. And they're doing it to get a couple of fucking rappers. Like, is this really that? Like, you're getting what they think it's some gang. I mean, you're not even you're going after who? Some yahoos, really, at the end of the day. You're not taking down Al Capone. You're not getting Osama bin Laden. You're getting, Young Thug and the guys from YSL Records. Ooh, that's going to keep the streets of Atlanta safe.
And also, I'll also say that, and I've said earlier that the prosecution, this is terrible because this is too unwieldy for any judge to handle.
Yes.
So I know a couple that probably could have done it, but the prosecution itself is ridiculous. They should have broken this up into much smaller component parts and gotten time, and have a bunch of little trials than this giant trial to end all trials. Why are they doing that? To me, that is very, very bad prosecution design. And I'll also be training. I love that kind of strategy, and so I will be using that strategy on the side of the prosecutor. So watch out if you're in Miami.
Yes. And then EDW Raptor for $20 says, "We bet the gold chat. Grax has got a gifted sub." And then Derper gifted 5 memberships. Thank you, Derper. And then D is saying, "I'm gay." By hard men working hard goes, well, hard. Yeah, it would go hard. And Katie says, "You should show more guns on stream to celebrate." Like, I was demonstrating. There you go. We'll probably get taken down for that too. But no, we were talking about on Friday night, the bump stock issue and the National Firearms Act. And I was showing John Dillinger's guns that they found when they killed him. And he had a lot of shotguns and semi-automatic weapons. He had a couple of machine guns, but that wasn't the primary weapon of the gangster back then.
No, and that only 1% of murders are committed with long guns anyway.
Yes.
So, and the bump stock is a long gun accessory.
Yes.
And it really isn't. I got to say, I don't think that the bump stock is a second. Well, we're getting off topic, but we'll talk about that later.
Yeah, we'll talk about it later. Unhung Hero gifted 1 membership. Thank you, Unhung Hero. Graxus said it was while I was at the hospital on Friday night. Okay. So 2.0 came home as I was about to start, and a beetle flew into her ear, and I couldn't get she was screaming, and she's like, "Get it out, get it out," and I couldn't get it out, and it was digging farther and farther into her ear. And we couldn't get it out. So I immediately took her to the emergency room. And I think they thought we were joking, but then the PA grabbed the forceps and he yanked out. Actually, I still have it sitting here. Yanked out this thing here. Now he's dried up a little bit, but this is, there you go, Steve. That's what went into her ear. It's like sunflower seed. And the nurses, when they saw it, they realized she wasn't joking. They were so sweet. Then they helped her out that she wasn't just like a lunatic. But I was about to start the stream, so it was set for 10:30, and then finally, 12:30, I finally started it.
Wasn't this in Star Trek: The Wrath of Khan?
Oh. Unhung Hero says, "Oh, I'm gonna come." Well, don't come. Lars Larson says there's no foundation, just sand. It's hard not to say that with what you see. And then real quick, guys, Analytical T for 50 memberships. Whoa! Let's go, chat. We got it. I'll give you for that, Analytical. Thank you. Holy shit. Thank you.
50. You're just killing it with memberships, aren't you?
I am.
Yes.
Yeah, no, you guys there's 600 people with memberships right now.
Wow.
YouTube will tell you in your thing, hey, here's how membership, congratulations. I was like, damn.
Yeah, congratulations, Sean Chat.
Thank
and
you.
Sean Chat is very nice. I will tell you. There.
Tomorrow night, guys, for the body cam stuff, we're going to have a lot of people in chat. It'll be fun.
What's body cam stuff?
So I do like a members only stream, and lately I've been doing just like body cam stuff. Like we've been
Okay.
watching body cams, so some of them are pretty fun. And there was like the one we did last week was all. I ended up finding all things from like Cleveland area, so I'm like, I know where that is. I know where that is. And Cedar Rose says, "Isn't there a murder in this case?" Yes, it's all foundationally built upon a murder in 2015. There's a couple.
This is
There's
the
a
one
bunch
that
of
this witness says he did.
Yes, this is the one Lil Woody is saying he did. He's taken up the slack on. There's a bunch of shootings, drug dealings, extortion, prostitution, all that other gang stuff is being alleged as well. But the murder is the foundational thing where they claim, Young Thug ordered it.
See, I did a RICO case with our state attorney's office when I was prosecuting. We had we targeted the top 13 guys in the gang, and we chipped away. I did several of the predicates and a lot of the pleas and several of the trials that established the predicates for the overall RICO, including a murder. So I've been through this, but this is not the way to do a RICO charge.
No, it's not. It's not. Benjamin Lewis says, Mr. Gosney, thank you for your service to America. Hunch says, I wonder if Young Thug didn't get on board to support re-election campaigns and city initiatives. Now he's suffering. Oh, that is one thing that will turn people the biggest supporters of reforms. I'm sure he's going to throw money behind politicians who he thinks will help.
How big is Young Thug? Is this a really big artist?
He was making money for a while. Yeah.
Well, everybody, there's a lot of people making money, but was he really successful, or is he like?
Well, he's been in jail for a while, but let's see, what's his net worth? Net worth as of 2024. He's worth $8 million as of right now.
Pretty good.
So he's still selling records and stuff. He's doing okay.
Well, my son knew who he was, so
yeah,
and he's not really a rap guy.
Reformed Convict says, I've been told, get it out by ladies as well. And Vodka Blood is saying, I'm gonna come. I get that. That's oof. Well played, sir. Well played. That's golf clap to you. So, all right, let's get back to the rest of this, guys. We got some stuff to look at here. So, Brian Steele submitted a motion. And he submitted this motion here, this Leviathan. And it's 20 some odd pages on its own, guys. And we might not have time to get to it, but we'll at least look at this part. It's a motion to disqualify. Okay, that didn't work. It's a motion to disqualify and recuse the judge from all further dealings in the above case, and a motion for mistrial, which was goaded by the improper conduct committed in concert by the court and prosecution. Now, it's one thing to say if you just write motion to disqualify, motion for mistrial. This part right here, which was goaded by all of that those next two lines are complete shit talking by the attorneys. That this is very much the point of no return. These attorneys are
what you got it. You got to put it up on the screen.
Oh God, I didn't share it. I am so sorry, Steve. So this here, it's a motion to disqualify.
Make it bigger.
Yep,
that's what she said. Ha!
It's a motion to disqualify and here. You know what? We'll just do this here. It's a motion to disqualify and to recuse the judge from all further proceedings. It's a motion for mistrial, which was goaded by the improper conduct committed in concert by the court and prosecution.
Amazing. I've never seen that is a big FU, and I've never seen. Have you ever seen a motion saying
no? No, this is like where you see those those motions, like where some crazy guy's representing himself and he says, motion for the court to go fuck itself. And you're like, this is almost there. This is almost like that. But this is being said in a very, very nice way.
All of these things need to be set up. The only purpose for these at this point needs to be for interlocutory appeals to get this thing shut down.
It's J-Rock says this is new and hilarious. Yeah, this is not normal, guys. But drastic times call for drastic measures, and this is a drastic measure to call them out. So he submitted this, and we'll get to it, but you guys should hear what the court has said. So the judge denies the motion, and we're gonna
upon a review of Mr. Steele's motion and affidavit, as well as Mr. Banks' motion and affidavit, that both contain assertions bare assertions and legal conclusions which aren't sufficient for the court to grant your motion at this point in time and refer it to another judge for it to be heard. So I'm going to deny the motion at this point in time. I invite you all to look at that. Baptiste versus the state. Just because adverse rulings have been made doesn't mean that the court stops the trial. So,
and this is something he keeps on harping on. Just because I said something you didn't like, and he's true. If that were the case, this is just an adverse ruling. But this is literally the court committing structural error. So
it's literally the court putting itself in position of the prosecutor doing Giglio Brady violations and concealing. It is the judge participating in unlawful conduct. I mean, it is the judge basically taking a bribe. It's that I'm taking a bribe. You've alleged I've taken a bribe. Well, I'm going to deny. Basically, it's just garbage. This judge is so out of line. He needs to be emergency removed. I'm telling you.
And Ag brought something too. On Monday, there was an issue potentially with some COVID exposure. And the judge said, well, we're all going to wear masks. And the court reporter was like, I ain't fucking doing that. So nobody's wearing masks anymore.
Good for a court reporter. Yeah, this guy has lost all respect.
Oh, yeah, he is. Yes.
And for me, I have no respect for this judge. Maybe he was a nice guy, but
Joe Lloyd's bringing up something. The court reporter resting on happy face. Every court reporter looks like that because they're typing. And there's a couple court reporters I've seen. Like there was one lady court reporter I knew. When she was typing, she was kind of like this and just listening along. But I asked her like, how does it? She's like, it's in all one ear out the other. I have no idea what you said, but after I've typed it, because they're just putting it down. They aren't listening or processing it. It's like talking it's like talking to your cell phone. Your cell phone doesn't actually remember what you said. Well, I get it might be listening. The government might be listening, but if it doesn't remember what you said, it's like a can and string. The can and string don't remember what you said. It's just they were the conduit.
Here's a good lawyer trick.
Yeah,
I'll give you a cheat. This is one of my things I teach prosecutors and defense attorneys, and something that I do, because a lot of times the judge or the opposing party will be very distracting, and they'll do things that are distracting, and they'll object. They'll do things. So when I focus my attention in my arguments, I focus them on the court reporter, because the court reporter is taking those, listening to me very intently without making faces. And I just run my game and ignore the judge and the other side. And that works. It's a good technique to like keep yourself from getting dehorsed by craziness from coming from elsewhere.
Yes. But yeah, guys, if I've seen other cases where people make fun of the court reporters. They're not listening. They're just typing. So yeah, they're kind of like on autopilot mode. It's also better that way, because if they're sitting there like this, that would be really problematic. They're like, oh my God, does she like what I'm saying? They're saying, them looking like a robot is actually, I think, preferable. And then, but yeah, let's listen to a little bit of this. And then Steve, there's like the next thing Brian Steele responds with that I think you're going to lose your mind over.
Oh, God.
I want you to hear. So just a couple more seconds here.
So I'm going to make that. I'll reduce both of the motions to recuse to an order, and I will file that so you can take whatever steps you need to necessarily after that. But I don't get into anything about the affidavit itself, argument on that. I just have to read it. Those are the only three things I do. And then if I find it to be not sufficient on its face, I go for it. I just make the ruling at that point in time, let you all take it up.
So that happened. And then Brian Steele got up, and this This right here, Steve. Oh boy. Oh boy, this is interesting.
I have read Baptiste versus State. I've read all the cases that I believe are applicable. I'm, best I can. But specifically, if the court would reconsider, and if nothing else, the Honorable Keith Adams and my joint affidavit in paragraph 12, we assert not a bare assertion or a legal conclusion, but we make facts that we specifically adopt from the Honorable Attorney Winchester, Collins, Banks, Nove, and Mormon's motion, where a person that they represent was in a meeting, ex parte, with the court and others, and the prosecutor and a witness, and specifically, they wrote in a pleading and under Parish, which is P-A-R-R-I-S-H versus State, which is 362 Georgia Appeal, 392 Division 1, 2022. The lawyer's pleading on behalf of the client becomes a statement of the client. And they said that this court got involved with speaking with Mr. Copeland and assisted in Mr. Copeland testifying against Mr. Williams. So I've added this court to the witness list. I plan on calling the court as a witness in the trial. I've added lawyers Hilton and Love from the district attorney's office to the witness list. And when I cross-examine Mr. Copeland, when that day comes, I'm going to ask him about how much pressure, if any, the court put on him. And you're going to be the one instructing the jury. And I just can't imagine how that's fair to Mr. Williams. So I just ask you, I'm not abandoning anything in the joint affidavit from the Honorable Attorney Adams and myself, but if you would just look at just even paragraph 12, again, if you didn't consume it entirely, I don't believe that meets a legal conclusion or a bare assertion. I ask the court to recuse.
I've read your affidavit, Mr. Steele, and I've consumed everything on it, and that doesn't change my ruling at this point in time, respectfully.
I also, on the transcript, I'd like the recordings and the transcript, and I object to the court going through it and deleting, because to me, the way I understand it, there is zero privilege. So I don't understand.
I'm not gonna, Mr. Steele, I can't argue with you about anything such as I've made my ruling, okay? If you have some other basis to ask for the recordings or anything like that, you're gonna have to put those in some other pleading. But
You are required. You are required.
Yeah.
I would shoot back. You are required to disclose this under Brady, and you are enabling the prosecutor to put on perjured testimony under Giglio. You, Judge, are withholding potentially exculpatory evidence that I'm entitled to under Brady.
More importantly, I would say he's suborning perjury.
Yes.
I mean, at this point, why not? He's already threatened to put you in jail. How fucking worse can it get? Judge, you are suborning perjury.
Right.
That is a massive threat. Like, that is a massive allegation.
It's true, but it is true.
It's true. He is suborning perjury by
he has already put it in his order that this is what happened. The judge himself signed an order that makes the statement says, "Is this all this was true?"
Mm-hmm. Yes. It's suborning means you're inducing or helping somebody. It's just like you're aiding and abetting perjury. But the term we use in court is you're suborning perjury. And that is kind of like a nuclear attack to use on one party or another. Like, I've been accused, like one time a prosecutor accused me of suborning perjury because the witness changed testimony, and that prosecutor ended up having to apologize because it clearly came out. I had never talked to this witness. I had no ability to contact them. And they were investigating that to figure out what happened. And the guy's like, "No, I'm just telling you the truth now. I don't know who the hell that guy is." So yes, but this needs to happen. He needs to be accused of suborning perjury. I would make that statement at this point. It has to be done. And then I would turn and tell these two people sitting here at the table, you're suborning perjury as well. Well, him, no, because he knows about it now, but he's not asking questions. He's just one of the others. But I'd argue ethically, he's in the same boat as the rest of them at this point. So he's got to be careful. But yes, the transcripts have to come out. And Brian Steele just asked for them. And
it has to come out. It has to come out right now. The guy's on the stand. You got to know what, because, and it's not just good enough to release it. Even if it has to release now, because that guy's testifying. When you're an attorney, you need to know what was said so that you can effectively cross-examine. Otherwise, you're not listening for the right things.
So. Yeah, so let's listen to the rest of this, guys. Here we go.
Miss Weaver is going to prepare the record. She does that. And like I said earlier, the record should be ready soon. And you all, as a defense group, will have the...
Also, that's really fucking disrespectful to be eating on the mic like that as the judge. Whatever he's chewing on. Sounds like he's chewing on something. Like, I don't care if it's a cough drop or whatever. That's really disrespectful for him to be doing like that.
Yeah. So
on top of everything else.
No, come on. Yeah, forget the supporting perjury. It's that great.
Well, it's all. Hey, Steve, all the rules matter. They all matter. Anyways, just listen to this.
The opportunity to take a look at that particular ex parte transcript that was done in chambers. Less anything that is totally that the court considers to be privileged. And I'm going to let you do that before you examine.
You don't have privilege. You have no right to redact. You are in no position to determine what's privilege because there is no privilege.
Well, and the fact that he's asserting things are privileged, that is not his place. The judge is not one that asserts any privileges on anybody's behalf. It's the parties that assert privileges, and he rules on it.
And if he has privilege, then he's now a witness.
Right.
That is. This is, Gigi, it gets worse. All right, I know it gets worse. We're just listening to it. Yeah.
Oh, does it get worse? How can it get worse?
Yeah, I mean, we're almost to the end, but.
Okay. Mr. Copeland. So you'll have everything that you have at that point in time.
Thank you.
All right.
And here's the thing. If you did this to an appellate court, if the appellate courts know about this, the people in these appellate courts are going to be sitting there saying, what the fuck is going on?
You need to get it in front of them. They need to get this in front of them as soon as possible. That's what I think. They're
watching this, pulling their hair out.
Yeah, they need to get it in front of them because they have to have something to rule on. They can't just come in on their own and do it. The bar can. That's why I'm saying the bar should come in and do it. But the appellate courts, in order to the Supreme Court of Georgia needs to have some matter of controversy. So if they do an interlocutory appeal on the recusal motion, the one that was just denied, that lays out those facts, they could immediately remove that judge in an emergency fashion. So, so that there's a couple avenues, but I'm suggesting that the bar needs to do an emergency revocation too. Emergency suspension.
Something has to happen, Chad.
It's just like stealing money from a trust account. This guy is stealing the rights of our citizens and all these lawyers right out from under him. They'll be care that the law doesn't apply to him.
Yes. It's just absolute insanity. And Steve, I know you said it's getting late, so I know you got to.
Yeah, I'm sorry, I got to go.
No, of course. Thank you for being here.
Yeah, it's a lot. So I went a lot longer than I wanted, but this was excitement, and I've covered it with you. I'll try to. I don't know what my future may hold, but I did want to come on. You invited me, and this was such an interesting train wreck.
Yes. Well, and Steve, if you are able to come on in the future, certainly, you're always welcome here. So.
Thank you very much. So, everybody, cheers. I'll see you later, man. Sean, good night.
Good luck, Steve. Kick ass down there.
Thank you. Bye-bye.
Steve Gosney, everybody. SteveGosney.com. If you guys want any of his books like Prepare or Death Penalty Desires, Death Penalty Debates, or Death Penalty Debates Maximum Due Process, which is the new one coming out, where he lays out a lot of the death penalty arguments and things in there. So just something for you guys to think about if you're looking for a good book. Also, Brucey, the One-Eyed Wonder Dog. It's actually a really good book for kids. Kind of gets you in the feels as you're reading it. You're like, oh, poor little doggo. But it's a good story at the end. So don't get too sad. Don't get too sad. It's got a good ending. It's got a good ending. Guys, I'm not touching the next stuff. Like I said, I don't know if it's legit, and even if it's legit, I am not touching it. So I appreciate you guys asking in chat, but I'm not going to address it. If it's what's there, it's what's there. So let's see here. What are you guys talking about? Yeah, good luck, Steve. Nice to see Steve. Good luck, Steve. Yep. Where I just missed something. We need Clyde, please. I don't know. I don't know if I can get Clyde. Let me see if I can grab him real quick. Hold on. See if he'll come around in chat. I don't know if he will. Clyde, come here, Bubba. Clyde, come here, buddy. Come here. We got a surprise, guys. Oh, you got a haircut. He got a haircut. Hi, buddy. Hi, Budda. Unannounced, but yes, he got a summer do. Got his hair did. Let's get a little dog ASMR. Aw. All right. Yeah, he got a haircut. Yep, he got groomed. Yeah. No, this is the real Clyde, Charlie. Gigi's saying, isn't the ex parte Brady material on its face? No, because, well, let's say, for example, it was just the prosecutors and the judge talking. That may or may not be Brady material on its face. If the witness is talking, if there's a witness there, that would automatically be Brady material. Do you get what I'm saying? It would all depend what they were talking about. Like if they were talking about how they want to do things at trial or whatever. Because remember, the prosecutors aren't witnesses and they may not be talking about evidence. I would argue we'd have the right to know about it, but it wouldn't necessarily be a Brady violation on its face. I mean, I think I would make the argument of whatever you guys talked about could be exculpatory. But if they said, no, it's not, then I don't think it would survive as a Brady violation. So Clyde looks confused. Who am I talking to? No, Clyde's always confused. Clyde wants to go back to see the lovely future Mrs. Mark 2.0. Yeah, he was sleeping. You tired, buddy? Huh? Mwah. Oh, you still smell like the shampoo is so nice. You don't smell like pee. You like you roll around and pee outside. All right, buddy. I'm going to put you down. Don't get caught up in the cables. There you go. Okay, what breed is that? He is, according to the 23andMe we did for dogs, he's like 30% Shih Tzu, some Terrier, some Lhasa Apso, some Chow Chow, something else, and then like 1% Ashkenazi Jew or something like that. So, yes, remember the USS Liberty. Yes, that is not a that's not a joke either, though. Yeah, the Liberty happened back at the beginning of June, the anniversary. So it's a bastardized dog. Well, we found him at we found him at the APL. He was such a good boy. Make sure I didn't miss anything there. EDW gifted 5 more memberships. Thank you. And then EDW Raptor says, Clyde, were you inspired by Nick's haircut? Oh boy. I hope not. All right, guys. So let's get to the rest of this real quick. We gotta get to the rest of this motion. Am I sniping Nick tonight? No, because I'm gonna go do something more enjoyable, like take a nap and go to bed. So no. I'm sure it'll be a tour de force of, a non-law channel being a law channel, or I don't know whatever it is he's going to do. Going to talk about relationships or whatever. I don't know. I hope it goes well. I hope, I'm not going to wish him $1 million, but I hope he's going to get a lot of super chats. I'm sure he's going to enjoy it. I hope it goes well for him. I really do. And that's a funny thing. This is tough love. I hope he gets out of this, whatever he's in, but he's got a long way to go. So that's how we're doing that. Sandy says, how would those docs get out? Aren't they under seal? Somebody leaked them. Those documents aren't under seal. It's just in juvenile court and for children's cases, that stuff is confidential. You're not supposed to go running around leaking it. Someone leaked it or someone got a hold of something they weren't supposed to get a hold of. Once again, that's presuming they're true. Presuming they're true. I've only been able to look at like one page that somebody blasted up. It uses language that looks like in one of those documents, but that doesn't mean someone else didn't get a hold of like another children's services case and just change shit around and make it fit. It's 2024, guys. Like, people will fake all kinds of shit. So who knows? If it's real, like I said, Lord child. If it's not and it's fake, that's a pretty good fake. So we'll see. So who knows? Who knows? Whoever gave that to someone fucked up, and more than likely, I'm thinking somebody came across something they weren't supposed to get into. So. Yeah, Johnny, like I said, if that's true. Yeah. Deanna says, I can't do that to us. We need you with us while we watch. Based on what we watched so far, it's been not like, watching something crazy to happen. Nothing's happened. So if something crazy happens, we'll watch it later. We'll watch the clips. Scorpion saying, going back to Glanville, doesn't this judge have any friends who are calling him and telling him he's acting like a fool? I think Steve is right at this point. If he did, he's probably ignoring them. And also there's the issue of, if you've got friends who are judges, they might say like, hey, Ural, you might not be doing this perfect here, buddy. Have you thought about like just pumping the brakes just a little bit? Not like, buddy, you need to get right with God. You were screwing this up. Remember that this is their colleagues, so they're going to approach this probably a very, like kind of sweepy. They're going to be sweeping real hard, even when they talk to them. That's kind of where I assume. Did the farms thread get shut down? No, Noel just locked it, apparently, from what I've been told, because he's trying to confirm. Eat what the monkeys eat says, come on, I'd rather give you the views. Well, like I said, guys, when stuff happens in this case, there'll be views to be had. Don't worry. There'll be clicks to be clicked, super chats to be chatted, and lulls to be lulled. Right now, I don't think it's one of those times. So don't worry. Those days will come. Yeah, these judges would approach Glanville with kid gloves. Let's see what Jeffrey Williams, that's Young Thug's real name, through his attorneys, filed a motion to disqualify and the motion for mistrial. So in support, they talk about the case starting, and we've already been through that. And they talk about within 5 days, on Monday, June 10th, is within 5 days of the filing of this timely motion. And how do we know that? Well, it says the 17th. So are we within 5 days? Well, you have to open up a calendar. So what does that mean? 5 days of it. 5 calendar days, you have the 10th is the day. You don't count that day. The 11th, the 12th, the 13th, the 14th. So you have Tuesday, Wednesday, Thursday, Friday. Day 5 is the 15th. That's a Saturday. That's not a filing day. That's not a court day. The 16th, Sunday. That's not a court day. You can't file within those days. So what does that mean? If your deadline falls on a weekend or a holiday, you go to the next available day. So, for example, if you have something due on the 25th of December, The 25th of December is a Friday. You actually have until Monday. And then depending on what you're filing under some civil rules, you get like an extra 3 days if it's by mail. But at the very least, you have until that Monday. So you got the 25th, the 26th, the 27th, and then you file on the 28th. That's your deadline. So that's why when you see this, that's what happened. Something to think about. Something to think about, chat. Sean, I have OCD. Fix the screen. Sorry. There. Yes, I'm glowing from the... Like I said, guys, running a different monitor. I'm sitting at the kids' I know! I didn't have a chance to fix the damn camera. Hopefully that's fixed soon. It'll be fixed, chat, I promise. We'll be back to normal very quickly. So, this court, along with the prosecutors, engaged on an unlawful and improper ex parte meeting with, among other persons, a sworn witness for whom a use of an order of immunity had been issued. Nobody in the defense was provided for any of the criminally accused in the case. In fact, the accused and the counsel were in the dark at the Star Chamber meeting. Now you guys understand. Now they're using like the loaded language of a Star Chamber. These guys are done fucking around. They are done fucking around. So Judge Glanville and the prosecutors admitted by silence and by statements in open court the meeting occurred. And only after the undersigned counsel revealed, based upon his information, this meeting occurred. And then we talk about the transcript of the proceedings is available, has been ordered from the court reporter. A video of the entire proceedings can be accessed online here. And I'm sure that, let's see what that actually is. Let's see what that is if you click on it. What is it? Oh, it goes straight here to Law and Crime. So that's very funny that they have it. I'm surprised they didn't timestamp it, but that's okay. That's okay. So they talk about the earliest opportunity. The court denied motions of the transcript. Why is this being all ridiculous? Oh, that's why, because this thing does it so weird, Google. Anyways, the court denied the undersigned counsel request for a transcript of the meeting and denied the motion for a mistrial. They talk about, once again, the Superior Court rules, the Georgia Code of Judicial Conduct. We've already talked about those, except as authorized by law or rule. No initiation nor considering ex parte communications by interested parties. And we've already addressed a lot of this, guys. We've gone through it, but they are just building the record. And they build the record by properly writing and doing everything they can. Ag says, that's the first time I've ever seen that legal document. Oh, I've seen that a bunch. Lawyers love to use that. Lawyers love to use that. They use that all the time. They can get away with it. JRX says, if I had 2 monitors, then this would have happened. Well, I'd be using 1 monitor, and that would be a lot smaller monitor. J-Rock, he's probably saying 1.5 to 2 million for Brian that he's making. Well, I bet. I mean, this is going to be his case for the next couple of years. So yeah, that money, when you break it down like that, that's still a lot. So in other hearings, both parties should be notified of the hearing with an opportunity to attend and voice objections. So they may be registered. And we talk about, once again, Judicial Code of Conduct, assuring fair hearings and averting ex partes. And we've already gone through that. They talk about the rules again. And they're saying the court has joined the prosecutors and is biased against Mr. Williams in favor of the prosecutors. So the trial court rejected the undersigned counsel's motion for mistrial. Instead, the court demanded to know how he came to possession of the information. The prosecutors stunningly sat mute and permitted this injustice to occur, and for the court to attempt to intimidate undersigned counsel. Yes. And that's true. They didn't say a damn word, and there's nothing wrong with calling them out for being pieces of shit. Then he says later, Prosecutor Love, she's the woman who wasn't in that video we just watched, argued the ex parte hearing with the witness was ethical, just, and proper. The other prosecutors remained mute. And that's true. They didn't say a fucking word, which means they're condoning it. They didn't have the balls to stand up and say that was wrong. So underclined counsel declined to join the antics and ignoring rules and ethical provisions. I hadn't read this yet, Chad. I'm reading this like with you guys right now. Oh my God, they are just talking straight shit. Unlike you guys, I follow the ethics rules. This is a sick ass burn. This is a sick ass burn. Oh. This is a burn, chat. You know, telling everybody else, hey, unlike you, it's very much like in The Departed. I'm the guy who does his job. You must be the other guy. You know, they just come in here and said, I'm the guy who follows the rules. Y'all must be the other guys. And he talks about Rule 1.6, which we talked about, the rule of professional conduct. Confidentiality. It has to be protected at all costs. And this applies to matters communicated and information gained to help your client by whatever source. You know, the lawyer may not disclose it except as required by the rules or other law, and he isn't required to disclose it. The court ignored ethical rules and continued to demand that he keep doing things, and that they kept claiming the information was somehow unlawfully obtained, and basically accused counsel on the record of potentially acquiring the information through eavesdropping, like a wiretap or electronic surveillance. You know, and I agree, that is very serious to allege somebody was wiretapping or eavesdropping somehow. Hold on, guys. Hold on. Okay, sorry about that, guys. Had to answer somebody. In response to these accusations, the undersigned counsel relied on the ethical matters of Rule 1.6 and the Fifth Amendment right to remain silent. Because remember, the judge is holding him in criminal contempt. You have all the same rights anyone has. I have the right not to talk. The court is so biased against undersigned counsel and Williams, the court ignored all laws and pursued contempt penalties to attempt to intimidate the undersigned counsel, to violate the law and ethics in order to continue to help the prosecution. Court issued its written order of contempt for 20 days. We've already seen that. The Georgia Supreme Court of Georgia granted certiorari to address the contempt order and granted a supersedis bond, which, remember, they told Brian Steele, look, you're all good, don't worry about it. So everything's fine there. The court violated the law by failing its duty to recuse from presiding over this contempt proceeding. In such proceedings, where the amounts of the punishment is delayed and where the contumacious conduct was directed toward the judge, or where the judge reacted to the contumacious conduct in such a manner to become involved, which he did. I mean, we saw the whole theatrics of that. The judge may give the attorney notice of the charges, but the hearing, and including the hearing to be heard, must be in front of another judge. Here, the court itself involved themselves in these proceedings. It created conflict of interest for the court because its own conduct is questioned at the heart of the issue. The judge did this. His own ethical issues are right now at the center of this. No, J-Rock, you're not correct in who I'm talking to. J-Rock says, cases like this in Trump here are rather embarrassing to a lot of Georgia attorneys. Oh, I'd be fucking mortified if this was happening in Ohio. especially if it's like a courtroom I'm in a lot or a judge I've dealt with before. Holy God, this would be really embarrassing. Really, really embarrassing. And guys, if you aren't aware, J Rock is an attorney down in Hotlanta or the Hotlanta area. Cedar Rose for 2 loonies or 1 toonie. Thank you very much, Cedar Rose. Says, towards your new monitor GoFundMe. Guys, hold on here. You know what? Fine here. Open up Gmail. Where's my Gmail? Hold on here. My Gmail. Not now. Let's see. Let's see here. Newegg. Or welcome Sean. Order history. Sign in. Let's see where my orders are because the RAM is in. I put the new RAM in on Sunday. The monitor stand is here that clips onto the table. Sold and shipped. Okay, it's in transit. Oh, it's a FedEx. Okay, so Tuesday, which is today at 2:51, it arrived in Perrysburg. So, I mean, it got there for day sort. They might have run it during day sort. They definitely ran it. They're definitely probably ran it by now because you go into Twilight because there's multiple sorts for FedEx. So it's in Perrysburg. That's the big FedEx hub for here. Toledo's the hub. Cleveland's a satellite. It's going to go to Cleveland. It'll get sorted tonight. I'll probably have it tomorrow. So there you go, chat. I'll have the new monitor by tomorrow, but the adapter probably won't be here by tomorrow to replace and fix the old monitor. So, but thank you, Cedar. It's on the way. I promise, guys. I promise. Did I hear it right? You're building a new machine? No, I already have a machine. I just upgraded the RAM. I put in a ton of RAM. David. Hi, David. How are you doing? I know it's late, but if you want to join, I assume it's like 1,000,000 degrees in the treehouse. You don't have air conditioning. I will send you a link. Where are you? All right, hold on here. Sorry guys, trying to reach out to. Why did that not work? Twitter, sometimes you suck at doing these DMs. Yeah, Steve, I sent you a link if you want to join us. Or David, I'm sorry, I sent you a link if you want to join us. I appreciate it. If you want to, if not, totally get it. So, is it tomorrow a mail holiday? Juneteenth is a mail holiday for the U.S. mail, but Federal Express, even though it's called Federal Express, is a private company. They'll deliver tomorrow. So, UPS, DHS, FedEx, they all operate. So, that's what's happening there. So, yeah, no, Miku, nope, we don't have to worry about that. I'll get stuff delivered tomorrow. And Amazon works tomorrow too. So, hopefully, I get all my stuff tomorrow for Juneteenth. We'll celebrate the freedom of our second monitor, chat. That's what the holiday's about. So let's get back to this thing, though. Let's get back to what we're talking about. Squiggle said, am I celebrating? Well, I don't have court tomorrow. So the court compounded its abuse of power. These guys are just over the very contempt hearing, which prompted the controversy. This court should have recused and allowed the contempt proceedings to be handled by a separate court. Further, the prosecutors again sat mute and permitted the court to attempt to interrogate another member of the bar who reported a violation of law and promoted the court's wrongful conduct by asserting the ex parte meeting was proper. And that's the thing, guys. These prosecutors are not off the hook. We can say, oh, yeah, it's Georgia, nothing's going to happen. But the judge is in deep shit, but they're right behind him. They're not safe. So the court denied Williams his rights to have due process rights to have his counsel. They talk about, again, that it abused its authority by holding the undersigned counsel in contempt. So let's get, this is the newer stuff here. The motion to disqualify or recuse the judge is timely filed. Motions for recuse shall not be filed later than 5 days after the affiant first learned of the grounds of disqualification. Remember, we talked about this. The 11th, 12th, 13th, 14th, that gets you to Friday, and then you have Saturday, Sunday, Monday, the 17th. So that's your 5 days. And if we check, the 17th was day 5. So that's how you get to it. So the Honorable Supreme Court of Georgia has taught that a motion to recuse is timely filed. If it is filed within 5 days if the affiant learned of the alleged grounds, excluding Saturdays and Sundays. And that's the thing. Like, you can't file it Saturday or Sunday. I mean, you can electronically filing, yes, but there's no requirement you electronically file. You have the right to go in and file stuff in person. So that's a court day. So, and they found stuff that clearly makes it from the Georgia Supreme Court. When you see things like this where it says like 291 Georgia, or it'll say 291 Ohio, or 291 Wisconsin, or Minnesota, or Nevada, that means it's that state Supreme Court. And this is from 2012. So the motion is timely filed. They reveal biased behavior against Mr. Williams' counsel. They talk about a trial judge's derogatory or prejudicial statements will be considered so long as a reviewable record has been completed. And they talk about the record seeing other instances too, when the trial court wrongly berated counsel in front of the jury. After a number of such incidents, the defense counsel, out of the jury's presence, moved for the judge's recusal and sought a mistrial on the grounds the judge has shown lack of objectivity and displayed bias against Williams and his counsel, and has assisted prosecutors in making their case before the jury. So judges have an ethical duty to disqualify themselves from any matter in which they have a personal bias or prejudice concerning a party or an attorney appearing before them. So it's not just for Young Thug, but it's the attorneys who might be getting treated like shit. There are a lot of things here that need to be done properly that are not being done. Joe Loy for 10 pounds sterling. The King Sterling. Long live the king. Or one of the kings, because it'll be another king after this. Says, for the celebration of the new monitor, take care. I have stuff to deal with later. We'll catch up. Well, Joe, thank you so very much. And you got the cute little pupper on there, too. That's a good looking doggo. Nothing ever wrong. I bet that's a good boy. Yeah, King Andrew. the creepy pedo king. That wouldn't work. No, the next one will be William. He's the next in line. Andrew's not in the main line. He would be there after if William and Harry both died and their families Harry's out anyway. But if William and Kate, all the kids died, then Andrew would be the next in line. But he's got a long way to go. He keeps on getting bumped down the thing. So trial judges shall avoid all impropriety and the appearance of impropriety. You guys have heard me talk about that before. The appearance of impropriety should always be avoided. It should always be avoided. Battle Love says Trump needs to hire the Steele guy. Here's what I'll tell you, man. Steve Sadow is just as good as Brian Steele. Like, Steele and Sadow, from what I've heard, are like the top dogs down there. Ashley Merchant, all those people. The Trump attorneys are actually really good. The Young Thug attorneys are really good. Both cases have phenomenal defense work in them. Axis, I just realized court citations are weird. I'm used to STEM references. Court citations are fine. They need to be footnotes, though. I don't like how legal citations shoved in the middle of stuff. Oh, Scott says Andrew's 8th on the list. Okay, thank you. Yeah, he's got a long way to go. Enough royal watching. Let's keep moving. Judges should disqualify themselves where the judge has a personal bias or prejudice concerning a party's lawyer. Within the context of the requirement, the word should means shall. Yes. The Supreme Court is mindful of the extraordinary pressures attending a criminal trial of this magnitude. On the one hand, defense counsel is obligated to vigorously defend his client at all charges brought by the state. Likewise, the prosecutors must effectively and ethically, that's another dig. That's how you point that this is more just twisting the knife. Effectively and ethically present the state's case to a jury. At the same time, the trial judge is charged with ensuring the rules of evidence and procedure are followed. When these interests come together in the courtroom during the trial, disagreements between the bench and the bar are to be expected. And what I mean by the bench and the bar is the judge and the attorneys. We're the bar. So yes, it's understandable there's going to be issues. But the issues discussed above represent more than mere friction between zealous counsel and a diligent jurist. The judge's conduct created the impression that he harbored an inclination to be biased against Williams and his counsel, and partial towards the prosecution. Higher courts don't need to decide whether such bias and impartiality actually existed, because judges are bound to disqualify themselves whenever their impartiality might reasonably be questioned. Like right now, including instances where the judge's behavior could indicate he has a personal bias or prejudice concerning the party or lawyer. As explained, the judge participated in ex parte communications with the prosecutor in which he assisted a state to influence the witness to testify against Williams. Those actions raise reasonable questions about bias. And because the impartiality is reasonably questionable, it's error to deny the motion for recusal. So, and that's the thing, guys. This is the motion the judge has already denied, but you can see they're laying it all out. And they say our highest court, the Georgia Supreme Court, has set forth 3 circumstances in which recusal is necessary on the ground of mere appearance of bias, even if the absence of actual bias, just the appearance. Williams does not waive actual bias as has been objectively shown throughout trial, but for simplicity, the appearance of bias is also met. So what he's trying to do here is arguing in the alternative, because he doesn't want to make an argument if he argues for the appearance of bias that he's waiving the claims of claiming actual bias. So that's what he's trying to argue. He's saying, even though I'm going to argue about this, I'm not giving up my claim here. They're basically they're making an argument in arguendo. Assuming these other things here, there's this also. 2 of these circumstances arise in the case at bar. Now what are they though? The third circumstance in which recusal is required on the mere appearance of a bias is when a judge has a direct, personal, substantial, pecuniary interest in reaching a conclusion against the litigant. Based upon information and belief, this circumstance is not applicable. And they're just saying, like, look, we know he doesn't have a financial interest. So first is when the judge becomes embroiled in the controversy. Yeah, it looks like it. It looks like it. In Exhibit B, the court favors the prosecution as attempting to sabotage the defense. Yeah, he's being embroiled in the controversy. The controversy is the case. He's helping Copeland testify. So Georgia courts have followed this demand when the judge becomes embroiled. The judge cannot be both the prosecutor as well as judge, where the judge reacted to supposed contumacious conduct in a manner to become involved. The judge may get the notice of hearing of charges, but the hearing is supposed to be in front of another judge. The trial judge became involved in the controversy as he necessarily applied his impressions from a prior bond hearing in reaching a finding of contempt. And he's not supposed to do that. Second is when the judge takes in a role in the accusatory process. Our highest court explains that prohibits a scenario where the judge orders witnesses to appear before him in order for the judge to gather facts to determine whether contempt proceedings should occur, and then the same judge presides over the contempt trial. This is because, which would make it a judge grand jury arrangement, cause the judge to become part of the accusatory process, and thus this judge must be recused. Here, Judge Glanville has ordered Copeland's lawyer and others to appear to give information, and he's going to determine who broke the rules. And then finally, the judge has a duty to recuse itself sua sponte. What sua sponte mean? Of its own accord. Of its own accord. Meaning it should say on its own, I need to stop. And I told you guys before, I've had hearings where you walk in, the court says, look, by the way, before we start, there's a potential conflict issue here. Do you guys want to kick me out? I'll do it right now. No questions asked. I'm good. But I've also had it where the judge says, I am bailing out. I shouldn't do this one. I don't think it looks good if I do it. It's an appearance of impropriety. So we're going to send you guys down the hall to the next judge. But yes, his impartiality might reasonably be questioned. And there's an objectively reasonable perception of lack of partiality, held by a fair-minded and impartial person based on objective fact or reasonable inference. And here's the thing, a regular person seeing this is going to say, what the fuck? This don't look good. The average person walking down the street is going to say, I don't like that. To warrant recusal, the bias must be of such a nature and intensity to prevent the complaining party from obtaining a trial uninfluenced by the judge's prejudgment, which is the problem now. To warrant disqualification, the affidavit in support of a motion must support the charge of a bent mind that may prevent or impede the impartiality of the judge. Recusal is required when the judge serves both as the accuser and the adjudicator in a case, which is what we're doing. And they talk about going through all of this again, guys. And, the prosecutors, they have abandoned their ethical duties by engaging in this meeting and sitting silent while the court held contempt proceedings and failed to reveal any Brady evidence from the meeting, including the fact this meeting occurred itself. And once again, they're all teaming up to take advantage of the defendants. The trial's constitutionally fractured, unfair, and lacks all constitutional, statutory, and ethical safeguards and protections of the due process of law. It's a complete disaster. No intellectually honest person could believe that coercing witness Copeland to testify in a star chamber setting meets muster. I agree. Yeah. This court has failed to follow the lawful path. That is a very damning statement, chat. Job well done. Says, stop, Sean. Oh. The court has failed to follow the lawful path. That is... I can't imagine ever writing that and, not being hyperbolic, but in this case, it's true. Court's lost its goddamn mind. Like, I can't blame these guys for making these arguments. Yeah, hold on, chat, real quick. Okay. So instead, the courts become the judge and grand jury and basically a prosecutor. And a potential sentencer, and thus must be removed from this case in toto, meaning in total, completely, instanter, which also means immediately. So those are very. You guys want some lawyer words? Use in toto or instanter. So, for example, if you have a motion that needs to be filed and it was like you were supposed to file it the week before, but you show up in court and you want it filed there, you're filing a motion instanter. Like, will the court accept it instanter? Or you missed the deadline by a day, can it be accepted instanter? That stuff, that's what that is. So just telling you guys. You get the inside baseball here. So when the motion is qualified recuse, it's the duty of the judge to pass only the legal sufficiency of the facts and ask whether these facts support a charge of bias or prejudice. Neither the truth of the allegations nor the good faith of the pleader may be questioned, regardless of the judge's personal knowledge of the controversy. Remember, we talked about this last week. The test is whether, assuming the truth of the facts alleged, a reasonable person would conclude bias exists on the part of the judge. And remember how he said, I looked at it and I determined it's not. No, the judge should have said, okay, yeah, you guys are accusing me all this serious shit. All right, it goes to Judge Bob. Judge Bob can look at it and say, yeah, we're not recusing him. It's bullshit. He doesn't get to decide what's bullshit. He doesn't get to decide. This court's conduct raises a strong finding. It's become embroiled in the case. And they move on. It's critical to the functioning of our courts that the public believe in the well, it's not the public that the public believe. It's that they have faith. I would argue this right here should be changed. You should have wrote that the public have a unshakable faith. Because it's important. The court has no faith in the court system. We have anarchy in the streets, folks. The public must have an unshakable belief. An unquestionable belief. A faith in the absolute integrity and impartiality of its judges. A judicial recusal serves as a linchpin for the underlying proposition the court will be fair and impartial. Yeah. Once again, they talk about Judicial Rule 2.11a and when he must disqualify. And this motion to disqualify mandates that Judge Glanville shall immediately cease to act upon any matters involved in the Young Thug case, shall immediately determine the timeliness of the motion and legal sufficiency. Well, yes, it was timely filed. And then 3, assuming that any and all facts were alleged to be true, whether recusal would be warranted. And then it says, if it's found the motion is timely filed, which it is, the affidavit is legally sufficient, which it is, and that recusal would be authorized if some or all the facts in the affidavit are true, which it does. And we already know this. It's all true. It's all true. Judge Glanville must cease. Must. Shall. He has to. Like you have to. Not, oh, think about it, or maybe, or might, or may. No. Shall, must. You will do this. From any further contact, and another judge shall be assigned to hear the motion. Judge Glanville cannot in any way oppose this motion. So, the joint affidavit clearly sets forth the facts. The allegations in the affidavit are not bare conclusions and opinions, but are 100% factual. Yeah. They talk about Rule 2.11 again, and they go through it. We've already talked about Rule 2.11. And then he says, further, this indictment must be dismissed and mistrial granted upon the courts and continuing prosecutorial misconduct. A constitutionally required fair trial occurring before a fair tribunal has been violated. It's including witness intimidation. Judge Glanville will be called as a witness along with the ADAs for the jury to understand its ex parte meeting to determine demeanor and credibility. And that's the thing, because they are witnesses to Copeland's statements, so they could be assessed. Do you think Copeland was telling the truth? Yeah, I think he was lying, or I think he was telling the truth. Additionally, Williams demands all ex parte meetings to be disclosed instanter, meaning immediately, in order to properly reveal the full extent of all violations of law and ethics. And these people are, Love, Hilton, and the judge are necessary witnesses. Can African rain give you monkeypox? No. Oh my, because I said in Toto, you guys are talking about Toto now? Jesus. I never meant to be so bad to you. It was the heat of the moment. When Cartman sings that, it's so sad and he's crying. It's very touching when he does it. You want Toto or Clyde? Yeah. Oh. So they talk about wherefore above in the affidavit attached, if Judge Glanville does not immediately recuse from any all things, this motion must be set down before another judge. And then further, a mistrial must be granted because of the violations of the law and ethics. Signed by Brian Steele, by Keith Adams, the straight G's out there, just making big time moves, just handling their business.
This is an OG call.
Just being real G's out there. Is Judge Glanville recused yet? Nope. Scorpion says, so what's the remedy? The judge denied it, so they're going to have to appeal up the chain and force it to happen. They're probably going to have to get a writ of mandamus and force this to be done. So that's where we are right now. Porcelain Thunder says, J-Rock, what are we celebrating by not being enslaved? Yes. An EDW Raptor for $5 saying, for your court-appointed monitor. Thank you. Thank you so much. So these are the attorneys for Jeffrey Williams, also known as Young Thug. And the Exhibit A is the order of contempt. We've already gone through this. And it's funny because the judge says, it talks about the only parties present for this ex parte matter were the court, meaning the judge, the court reporter, representatives from the state, Mr. Kenneth Copeland, Lil Woody, and counsel for Mr. Copeland. So they admit there's an ex parte thing that happened. They admit this happens. And this is Judge Glanville's order to send him to jail. He's got, 20 days of contempt to serve over 10 weekends. Remember, it's not happening. It's been put on hold. Then there's Exhibit B, as in biatch. Because that's what they just did. They made Glanville their biatch. This is the joint affidavit of Brian Steele and Keith Adams, Esquire. I know people are like, Esquire's cringe. Well, to put it in your documents isn't cringe. It's just like, hi, I'm Sean Martin Esquire. You don't do that. But I put Esquire in my cards because it looks fancier. And also just more shit on there, so it takes up more room. And this is literally all the stuff we've already talked about. This is just the same thing they've already addressed before. That there was a... the ex parte hearings have happened. They keep on laying all the stuff we've already looked at before. This court never assured that this Brady evidence would be revealed, and there's issue about the Brady evidence includes the fact that meeting occurred, and we're not getting it. And now the judge has said, I'm going to redact the transcripts. Well, how do we know those redactions aren't Brady material? You don't know. They keep talking about the improper ex parte meeting on June 10th. Yes. And this is their affidavit. And Brian Steele signed, and then Keith Adams signed. It looks like they had the same Courtney Edwards. Courtney Edwards something. Who is their notary. It looks like they used the crimp. Is that a crimp or a stamp? I can't tell. Because the old way of doing notaries, you had the paper crimper and you could shade it in. Although that's a goofy looking stamp. My stamp is not that exquisite. And then the certificate of service. And these are to all the attorneys it got sent to. And it does. I wonder if they sent a courtesy copy, but who knows? Signed by Brian Steele, Georgia Bar, number 667640. So there we go. Is Keith Adams a black guy that tossed himself on the coals? Yep. He's the co-counsel for Jeffrey Williams, Young Thug. He's the one who said, "Hey, judge, I learned the same stuff too. What the fuck you gonna do about it? Do something, pussy." And he challenged the judge to put him in contempt too. The writ of mandamus. No, not a writ of Matt Damon either. Harvard Warble says, "When do we get my monitors back? Probably by Thursday at the latest. Hopefully by tomorrow." What's the timeline? I don't know. Probably within about a month or so, Glanville's going to be gone, but it's going to take a while, guys. Even the court moving fast, it's going to take a while. The court moving fast, it's going to look like glacial in your eyes. In normie time. Court time passes, it's like dog years, except in reverse. Normie time moves fast. Normie time is like dog years. And court time is like people years. You know, dog age is 7 years for every year we age. Well, you know, you guys are going to be like, "Oh my God, why is it not done?" And we're going to sit here and say, "Wow, that was fast." Oh no, here it says the writ of Matt Damon. How do you like those apples? No. Does Esquire mean cuck? No. Was Corey here? No. Oh, I think he was earlier, but yeah, he went to go. He had to go get his broom dusted off. Gotta trim the bristles. Gotta have that even cleaning surface. Do you use cerulean rail on your business cards? No. And Ramallah font? No. I don't have bone with Ramallah font face, typeface. J-Rock saying it's a crimp with an inker? Wow, that's fancy. That's like technology I don't understand. Um, anyways, hold on here. Um, yes, this is I take it good saying it's at the point where they've had to pull their dicks out. Yeah. Yeah, this is they whipped out their dicks and slapped them on the table. This is this is getting intense. Robert says, "I bet Fanny's sweating over this case too." Um, Probably not, but eventually she will be if she's smart. This is not a good look for her. Like I said, this is a preview of the Trump case. There's going to be some better attorneys, but still, it's rough. Oh, J-Rock. Oh God, you're not helping me here. Saying the Georgia Judicial Qualification Commission polices judges like the bar does lawyers, so probably not very hard. Chadwick says my accountant has a line item for well, Seema Martin. Well, that's I don't know who Seema Martin is. I mean, Sean Martin, Esquire, for my hookers and below budget. Yes. Oh. Love has been absent or sidelined. Yeah, or she might be in the middle. Something happens. Who knows? Yes, I would like to think that's her and her kind are like panicking and they're figuring out what they're going to do. What, you know, who knows? Who knows? Garrett says there'll be more sweeping than in a curling tournament. Yeah. Craxus says I was a graphic designer during a time everyone wanted papyrus font for everything. Oof. Oof, that's not good. You You are a brave man for getting through that. So. Seem is Sean's evil twin separated at birth. Kimbo says there are 3 attorneys in the United States named Sean Martin, and one of them is an alleged pedophile. Identify yourself. There's 3 of us. Are there really 3 of us? Because there's 2 attorneys in Ohio named Sean Martin. The difference is our middle names. I still get his stuff once in a while. I still get papers and court filings for him. Brooks Euchre is saying, since we're halfway through 2024, what other shenanigans do you expect to come up? I don't know. Because if you had told me this was going to happen, I would have told you it's impossible. The system doesn't work like this. We wouldn't let it happen. And oh my God, it's happening. So I don't know what's going to happen going forward. The sky's the limit, really, at this point. So. Am I saying Sean ate the other 2? Yeah. Oh. It's a pretty common name, but not as common as John Smith. I understand, but yes. So where are we? Oh, looks like you guys are all caught up. Jen McCabe gets arrested. That would be hilarious. Sandy says, if you want to speak freely, no secret meetings. If you want to go talk over at potentiallycriminal.locals.com with the 1-month free code, Booger Sugar, you can join the Safe House. And the Safe House is a chat that's always up. You can hang out and say whatever you want. So that's at potentiallycriminal.locals.com. If you want a place to go, Sandy. But I got things to do tonight, like go to sleep and take care of stuff in the morning. So if it's gonna be a dumpster fire, don't worry, it'll still be the dumpster fire in the morning. You've had 3 Seans in one class and several Martins, but no Sean Martins. Well, when I was a kid, I think it was 4th grade or it was 3rd grade and 4th grade. There was Sean, me, S-E-A-N. There was an S-H-A-U-N-N, Sean. And then there was an S-H-A-W-N, Sean. So there were 3 Seans. So you're 2.5 hours late to the blog, bummer. Yeah, I know, I'm sorry. But I appreciate you being a deplorable and bitter clinger. Dumpster fire at Rekieta Law. Oh, geez, I'm so sleepy. Well, like I said, I hope it works. I hope he does whatever his new format is. I hope it works for him. Sam Hartman says, I had a Mike's at work one time. We just started giving them numbers. Yeah, or like the TV show Rescue Me. There's like Mike the Wop, Mike the Mick, Mike the Jew. They just have a bunch of different names. What time are we blogging Kieran Reed tomorrow? Okay, guys. So all the voir dire stuff that happened today for Kieran Reed, we will catch up tomorrow at 10 a.m. That's going to be the plan. We'll get it all caught up. And remember, it's only like a half day, so we'll be done by like 1 or 2 o'clock anyway. And then tomorrow night, we'll be doing the members only stuff for everybody. Guys, we do members only. I'm trying to do one at least once a week right now for everybody on YouTube. If not, at least every other week. So tomorrow night, we're going to do it. We've been doing a lot of stuff like watching body cams. It's been a lot of fun. Or if other stuff pops up, it's kind of like a free mode. Tomorrow's a holiday. Yes. Court happened today. There's no court tomorrow, so we're going to catch up and watch. We're a day behind, Scott. So we're going to catch up with today's stuff tomorrow. That's what we're going to be doing. Saying Willie Mays just died. Really? Willie Mays. Oh, he did die. Well, you know what? Oh, The man stole the World Series from Cleveland, chat. Man stole the World Series from Cleveland by doing catching a ball and fucking bombing it downtown from right field. Just chucked it back in and kept Cleveland from winning the World Series. Say hey, Willie. Yeah, he hurt us. He was 93 years old. So yeah. Michael's saying, what are your thoughts on this judge? Is he gonna out of here or is somehow gonna stay on this? He needs to leave. This judge is fucking insane. I question his competency and his fitness to be an attorney right now. Like, the man does not have the mental fortitude to do this. He won't stop doubling down. He won't admit he's wrong. He won't stop. This judge has gone rogue. He's a liability. He's the thing like we're afraid of. And thank God never happens. So no, this is bad. It's really, 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 really bad. It needs to stop. It needs to be stopped. He needs to be stopped. Rest in peace, the Say Hey Kid. Yes. Willie Mays and Billy Mays together again. Oh. Yes. Could he have a brain tumor? Yeah, it's always possible, but I'm just thinking this sometimes things break people. So, yeah. Or maybe he was just an asshole all along. Fire is the test of gold. Adversity is the test of man. So, guys, that is it. I think we're all caught up. I got to caught up on the super chats. Thank you guys for making it rain earlier. I appreciate that. And then, yes, guys, tomorrow morning, 10 a.m., we will catch up on the Karen Reed stuff and get it done. He outlasted Little Richard. Ooh, yeah, good point. And yes, we will take care of Juneteenth tomorrow. So, yeah, got to see it back on YouTube. What got kicked? Pictures of guns, and I think the Switchy clip too. I don't know, but I think it was the picture of all the guns we were looking at. Who knows? Who knows? YouTube being gay is why we got kicked. So that's it, guys. I know there's a stream starting in about 10 minutes. That'll be fairly interesting. I encourage you all to watch it. I'm sure it won't be without a set of fireworks, but we're not going to be. I'm not going to be streaming it. If you guys want to watch it, you'll be able to watch it there or somewhere else. 619 people. Oh, the numbers are dwindling now. So I will put a permanent shooting tomorrow. Read into that what you want. Am I going to drop Chattel Wirch on Juneteenth? Oh, no. That's not a bad idea, though. So, guys, in the meantime, we are going to keep going. We're going to go from here. The saga's not over. The saga's not over. We'll keep covering updates that get significant. So, those of you guys who are all new, I apologize. I didn't introduce myself. I'm potentially criminal. I'm an attorney. I'm in the Cleveland area doing all kinds of criminal defense lawyer shit. And I think watching these guys down there put in that work is impressive. So, like I said, hopefully if I'm ever in that position, I'm doing it just as cool as they are. So, there's no mail tomorrow. Yeah, it's a federal holiday. So, good night, everyone. And remember, until next time, just because you did it doesn't mean you're guilty. Good night, chat. Take care. Sleep well and happy Juneteenth if you happen to celebrate it.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just to a local